the bench has changed, my lord, that matters don't discharge. May I file a memo, my lord, but subject to pleasure of my lord?
Which one?
It's a, the number is. It's a 2021 criminal appeal. Of a person who was a decorated officer on the verge of his being posted as superintendent of police, and 197 having been rejected. Soon after, my lord, initiation of proceeding, his house searched and DA initiated, and
Give that number, we will include it in the list.
yes, yes, I'll be deeply aware.
Yes.
Filing the memo in the
Give
course.
that. Take the number, include it in the weekly list, we'll see.
Deeply obliged.
And if you have paper book and all, please
Yes.
give it to Mr. Rijvi
Yes,
so that
yes.
he will get ready.
Rizvi will not be.
Who is appearing?
Mr. Maharana will be appearing.
I'll give it to the.
I can just.
I'll give it to the.
I can pass it to
Vigilance
Mr.
Counsel.
Maharana.
So that on the pretext of, non-availability of.
No, my lord, we'll make sure of all that, my lord. Deeply obliged.
Include it.
Plus criminal appeal.
Tomorrow?
Another criminal appeal, we have filed the paperwork for RB hearing. Maybe listed for acceptance of the paperwork. Vigilance.
That is in list, acceptance, no problem. And which year appeal? 21. It will go in the weekly list. Accept the paperwork and.
Yes.
Yes, tomorrow, list it tomorrow. Tomorrow, sir.
Yes.
My lord, I'm sorry, mention item number 7, my lord. That connected matter, I am appearing for the appellant.
7.
My 7 is second matter, my lord. 2 matter I have listed. Second matter, criminal appeal 100.
Yes.
My lord, that matter I am appearing. Unfortunately, I have misplaced my file, madam.
But you are in the second matter.
Yes, ma'am.
Who is appealing for the first matter? Let him come because we will have to see.
First matter, Tahsildar was accused, madam.
That's right.
Tahsildar has passed away.
Whatever.
Achha, hold on.
I'll accommodate you, but let us see.
Ma'am.
Item 29.
20?
29.
29.
That is remains, last night I have telephoned him on his contact number, but it's someone from Koraput says it is not his telephone number. Why you are bothering? I am ascertaining whether the man is alive or not. Let's say take it 1 week after I have given a registry letter.
Where from you will get a new telephone number within
No,
1 week?
the telephone number he has provided at the time of filing.
You must contact the local lawyer who has briefed you.
No,
That is-
he has come directly.
Oh.
They must be having his address also. So
I have
letter can be
given-
sent.
I will just see, I will direct the local police to locate and file a report. That will help you. Otherwise,
Yes.
where will you search him?
Yes, yes.
Wait. When it comes, I'll pass that direction. And you tell me which police station and also that it is a criminal appeal, huh?
Yes, my lord.
We will see. We will give a direction to the concerned. Yes.
Item 8, my lord.
8.
2001 matter, no communication with the petitioner. Send a letter to pray for
We'll
2
see.
weeks.
Let it come. We'll see what can be done.
No, item 52. Item 52.
50.
52.
Yes.
3 appeals are there.
Yes.
In the second connected matter,
Hmm.
Criminal Appeal 498 by 2009, both the appellants are dead.
Okay.
So the appeal has to abate. I am filing a memo.
Who are appearing in the first matter?
My lord, 4 accused persons,
Hmm.
3 appeals.
Okay. Take it at 2 o'clock. We'll see if somebody take this memo. I'll pass it that order insofar as the 2 o'clock. Insofar as item number 2 is concerned, sub item number
Sub
2,
item 2.
498 of 2009. Then counsel for the Mr. Mishra, then counsel for the petitioner submits that both the appellants.
Yes, both the appellants are dead.
Both the appellants have died, and he has filed a memo
Yes.
to that effect in view of the fact that the appellants have died. The appeal stands awaited. Okay?
Obliged, madam.
Awaited. And other matter at 2 o'clock you take so that we will intimate.
Yes, I will.
Will it reach otherwise? Yes.
Yes, my lord, it may reach also.
Whenever it reaches,
Whenever it reaches, we can.
it has to be intimated to the other part. You are free. No problem.
No bless.
32. Thirty-two, sir?
Yes,
Yes.
that is here.
2008.
2008 matter.
Yes. I'll not take it up for 1 week. Let it be there on. Please,
1 week,
I'll not
yes.
take it up. Don't worry.
Take up.
I'll not take it up.
Well, item,
Mr. Rijvi, whenever it comes, you.
I will remind it, man.
item six
Not
to,
this week, then.
item 6 to 1, the infectious my lord. I'm challenging the
Yeah,
rejection of a
report here.
discharge petition.
One minute.
Charge already
One
framed, my
minute,
lord.
1 minute, let
My
me
lord.
read there. 60.
1.
What are you challenging?
The rejection of a discharge petition. Now charge are framed, my lord. Pretty
Right on.
infectious.
In the present petition, petitioners or how many petitioners?
1 petition.
Petitioner has challenged the order dated 13/7/2023 passed by Lieutenant Special Judge Vigilance Bhavani Patna in GR case number 16 of 2021 bracket 2 Vigilance whereby charges whereby his application under section 239 CRPC has been rejected. Then comes for the petitioner submits that subsequent to the impugn order, the trial court has framed the charges against the petitioner. In view of the said development, the petition nothing survives in the petition. Accordingly, the same is dismissed. Yes.
That's it, item number 77. Convicted under section 138 of NI Act.
61 disposed of.
Settlement is going on.
61 disposed.
70?
77.
Yes.
Convicted under section 138 of NI.
Who are you?
I am for the petitioner.
Okay.
There is a settlement is going on. Opposite party
I am for
is
the opposite.
praying for 10 days time. That's it.
This petition is arising out of arising out of a complaint under section 138 NI Act. The petitioner and the opposite party number 2 being represented by the council present representative of council jointly request for an adjournment to settle the dispute amicably in view of the same. These matter next week they will read it.
That's it.
When?
Next week, 15 days, at
Huh?
least 10 days time.
10 days, that's what. 22.
Yes.
Yes. Yes. Anyway.
Item 65.
60?
65.
65.
Right. I
Okay.
pray for 3 weeks time. He is suffering from cancer and throat cancer. 35 chemotherapy already taken. He is admitted also. And so submitting the ordinance.
It's all right. No problem. No, but
65.
Opposite party is.
this is criminal appeal.
Appearing for opposite party is.
You are appealing for?
I am the petitioner. Say, Bhubaneswar advocate ke asu nahanti.
Item 65, it is a criminal appeal. 301 of
Bye, bye.
2016.
It's not an appeal, it's CRLM.
Modification of
Modification.
There is modification of Sessions Code interim order continue till. What is the modification? I'll allow it. 1 minute.
Three time तीनटा installment पे तीनटा insert देई पारना.
Appeal रे 139 act.
हाँ,
Appeal रे पहले 1 lakh 27 report करे पे. 3 installment, they have not given that, against that, he come here and obtain the stay order. Appeal
Who
is
is
pending.
appearing for the other side?
My lord,
Who is appearing for the other side?
advocate of the Bhubaneswar bar से he is not attending the court, my lord.
Respondent.
My lord.
I'll extend the time for.
My lord.
Let's see the condition.
Condition भाई देखो.
But in fact, appeal is pending there, my lord. Just before the sessions code, 139.
I'll allow it and go and move an
Only,
application.
only because this, my lord, is the this criminalism, that is the appeal, not disposed of.
Let us see, I'll dispose it up. I'm giving a liberty to you to go and move appropriate application before
Because
the.
he is
court.
bedridden and.
That is why I'm saying.
My lord.
There is no point keeping it.
My lord.
Let us see. What is this? What is the prayer?
What do you have? Just put.
Huh?
61 around.
For you, na?
61
I'll take it up.
62 around.
I'll take it up.
61. 62. 61.
Pardon,
I'll take it up. I'll just wait for some time. I'll take it. Yes.
item 120.
120. Yes.
I am appealing for the petitioner. It's a hearing, revision hearing.
Yes.
I have got some personal because my marriage of my nephew Your Lordship may fix it to 22nd. I'll come prepared.
I don't think 122.
120.
41.
41 is-
120 will not reach, sir. Why do you worry?
Released.
ଓହୋ ମୁଁ ନେକ୍ସଟ ୱିକରେ ରହିବିନି ତ ସେଥିପାଇଁ ଫର
It's all right. I'll recommend it. Note corruption. And there is a festival in his family. Don't worry. You relax. It reaches, then I'll let them. And there is no chance. I don't think it reach within. Yes.
Still, we will not invite your Lordship say the wrong impression of on us.
No. It's all right. I'll take it. Note correct video. In case of then. we'll-
Obliged.
Don't worry. Yes.
Another prayer matter, 142 matter, no instrument kindly dispose. Criminal revision, local file names are responsible.
142.
Matter kindly dispose.
Let
No
counsel for the petitioner submits that he has no instruction in this matter. It's arising out of.
Well, it's a file to nail a local.
No. It's arising out of conviction. Conviction then it can't be disposed of. We have to appoint someone. Learn counsel for the petitioner submits that he has no instruction in this matter. Therefore, he wants to recuse from this matter. Accordingly, his name may be deleted from the cause list. Who is that who can assist? Can assist? You come, you assist now. 41,
142.
142. Mr. A.K.D. is appointed as amicus curiae to assist the court. He is directed to supply the paperwork. Do you have the paperwork with you?
No, contractors and sir,
No, you must be having your papers with you.
over kitchen paper, it's a copy touch. What's he can do? Say, Mona,
Just see, collect it from, because he has a problem, he can't contact his client. So he wants discharge. I have discharge and you have to take care of that matter. And whatever paper he has, you take it and the registry will also supply. Okay, please. Let it retain in the board. Okay. Get ready. Whenever you are ready, you tell me so that I can take. This is a revision petition. Yes. What are the offense, by the way? 376.
Then 376 is my matter. 376.
Then it needs hearing. Yes. Huh? Yes, I have passed your. Next week, no. Next week or week thereafter. 2 weeks ago, so that he can get ready. Okay. Yes.
Item 62. The NDPS matter. And brown sugar, 20 grams of brown sugar, my lord, recovered from the possession of the petitioner. And earlier occasion, this petitioner also involved in another case of NDPS Act, my lord.
62.
My lord. For that is in bread.
Adjourn kodu. None APS for the petitioner adjourn. Mention content take up. May bill better this to come. Yes.
Item 63. 63. 500, 5 quintal 16 gram kg of ganja, my lord.
5 quintal.
5 quintal.
What is his role?
Lord, he is carrying the ganja, my lord, outsider. For that is in earlier occasion. Your lordship, he has filed a application, petition filed application for interim bail. For that case, my lord, instruction sought, my lord, and he is outsider, my lord. For that is unable to get the instruction, my lord.
Non-APS.
The IO may be specifically directed to produce case diary and instruction also, my lord.
Whenever he come, we will pass the order. Non-APS
My lord.
adjourn.
Urgent.
Adjourn kodu.
64.
May I please, Lordship? The second time, Your Lordship, first of the Lordship directed to move up to charge sheet. Meantime, charge sheet submitted, custody essential 12/9/2023.
12.
12/9/2023, Your Lordship. And a 42 kg, 300 gram of ganja.
Where is that order, earlier order?
Earlier order, Lordship, file is there, Lordship, one copy, Lordship.
Sir, all these matters are now, no file is there with us. If you throw this paper, where will I keep it?
My Lordship,
Now, gone are those days, you can give the paper, I can see that and
Yes.
put it in the file. There is no file. They are empty-handed, I am empty.
My lord.
If you
That-
give some paper,
Yes,
how
sir.
where will I keep that paper? It has to go to the digital
Yes, sir.
file. You have to file these documents. These are minimum. How will I know that I
Yes,
had
sir.
dealt with
That,
it?
that will be, but,
These things are minimum anyway.
yes, sir.
Let us see. I'll not.
Further, I'll-
take it. 42 kg,
But 300 gram, 2 person in a motorcycle LRC. Petitioner is the pillion rider,
ganja,
my lords. And for 21
incident,
Antecedent one, antecedent, my lord, that is
No.
not a similar nature.
huh?
379,
NDPS ର କିଛି ନାହିଁ
379.
ଆଉ 21 years boy lords. Young boy.
Badabazar PS case number 159 2016, 16 year, 379 34. Not similar nature.
NDPS ର କିଛି ନାହିଁ
He is multifarious.
Why?
He is multifarious. 42 kg.
My lord.
my lords.
You are in custody?
Got to 12/9/2023 lords.
12,
12/9/2023.
12, 9, 23. Any co-accused?
Co-accused suspended one G Raju.
Hmm.
He has not
Conscious
away.
conscious possession from you.
हाँ, my lord.
ମୋଟରସାଇକେଲ ରେ ସିଏ ଚଲାଉଥିଲା ଇଏ ବସିଥିଲା ବ୍ୟାଗ୍ ଟା ମଝିରେ ଥୁଆ ହେଇଥିଲା ମାନେ ମୁଁ ଧରିକି ବସିଥିଲି ଯିଏ ଚଲାଉଥିଲା ସିଏ
In front of you, bag was there. You are the pillion. In front of you, bag was there.
Mind-
You are more conscious than the rider.
Right.
mind-
Behind the rider, it was there. In front of you, the
That-
bag was there.
that
You
is
are
there.
more conscious. Yes, Mr. Raghavan.
42 kg, my lord, 700 years.
କଷ୍ଟଡି ହେଲାଣି 21 ବର୍ଷ
Charge
ଥିଲା
sheet submitted 5/3/2024.
Yes, that's
Right
it.
on. Earlier, the petitioner approached this court for grant of bail. Grant of bail. This court on 5/3/2024 passed the following order. There is the order. 5/3 passed the following. And then counsel for the petitioner submits that charge sheet has already been submitted by the police on
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 5/3/2024
24.
5/3/2024.
page 70.
Thereafter, he moved an application before the trial court for grant of bail. The trial court, by order dated 10/4/2024, rejected his bail application. The petitioner is in custody since 12/9/2023. He was the pillion rider, pillion rider. The co-accused G Raju, who was riding the vehicle, is absconding. Absconding.
700.
300.
300.
42 kg, 300 grams of contraband ganja has been recovered from the petitioner. Mr. Ragada, learned counsel for the state submits that the petitioner is involved in one case. However, it is not
Similar in nature.
similar in nature.
Malad,
You are local or outsider?
Outside lords. Andhra Pradesh.
Andhra Pradesh. Then you will vanish because one of the co-accused is absconding. Once bail is granted, you will also abscond.
No, my lords.
And,
Any local security lords, any condition imposed by appear lords. Any condition.
Local security. And
Local
yes,
security.
you
alone.
you tell me the condition.
He will appear each and every day before trial court and also not leave the jurisdiction of the.
And
Yes.
the
that comes.
condition, the petitioner taking into consideration the period of custody and the recovery of the ganja, quantity of recovery of the ganja, I'm not trying to grant bail also, and the conditions, with the conditions. Mr. Ragada,
Malad.
give the conditions
Malad.
in writing. All conditions take it from. And I think he should appear every month
Malad.
before the local police.
Local.
My lords.
Before the local police, local security, and everything.
Obliged.
Local security, every month he has to
Malad.
appear before the IO
Ayo.
and all. Okay.
Obliged.
Violation of condition and that.
You give the condition.
Malad.
Yes.
65.
Day after tomorrow, I will contact ସେ ହୁଏତ ପଇସା ଦେଇଛି କି ନାହିଁ କିଛି ମୋ ପାଖରେ ଇନଫର୍ମେସନ କିଛି ନାହିଁ ସେ ପଢିଲେଣି ମାନେ ମେଡିକାଲରେ ସାର୍ ପଢିଛି ଟିକେ ଥାଉ ଦିନ
ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଯାଉନା ସେଠି ଆଉଥରେ ମୁଭ୍ କରିବେ better ହବ. It will better, my lord, if you will my lord, again approach the same court for a reduction of the amount 1,20,000. Then
ପଢିଛି କ୍ୟାନ୍ସର
No, no, I'm giving you liberty. I will dispose it up with the liberty to you to go to the appellate court. Huh?
Appellate
It
court.
is appealing, pending
Appellate
for
court,
appellate court.
appellate court.
Necessary quashing the impugn order, 26/10/2016. Page number
Page number 16.
3, na? Yes, 26.
Session Judge Khorda.
26 what is that? 26 what is that? 26/10/2006. The advocate of the appellant present in the court and files two separate petitions. In one of the appellant raised to the court to permit him to deposit 30,000 rupees. In another petition, he raised for the rest of the amount 90 rupees in 3 installments.
1,27,000, 3 installment.
Petitioner is challenging the order dated 26/10/2016 passed by the Sessions Khurda in appeal. In criminal appeal number
17
criminal appeal number 70 up to 2016, whereby the application moved by the petitioner for depositing the amount, depositing the check amount under 3 installment has been rejected. Then counsel for the petitioner submits that the petitioner is bedridden and he is suffering from cancer and has been undergoing treatment. Therefore, he seeks liberty to approach the court below, seeking variation of the condition to deposit the amount as directed. In view of the same, the order dated 26/10/2016 passed by the Sessions Khurda in appeal number so is set aside and petitioner is granted liberty to move appropriate application for variation of the condition to deposit the amount as directed. With this liberty, the petitioner
Non-appeal for opposite party under.
non-appeals for the opposite party.
Opposite party 2, my lord.
Opposite party. And move application in view of yes.
66.
May I please, your lordships?
Yes. Yes, Mr.
66, your lordships, is a CBI matter.
Yes.
Am I audible, your lordships?
Yes, I can.
Am I audible?
Yeah.
Your lordships, there is a Sanskrit proverb, Ahimsa paramo jatarth hinsa ahimsa.
You are seeking cancellation of the bail on the ground that the petitioner has been threatening the IO. Is it?
Threatening the, your lordship, your lordship may kindly allow me to read only one line of the case diary, 5/10/2018 at 12:50 PM, your lordships. May I read, your lordships?
Yes.
Accused Vikas Singh appeared before me without any prior intimation, appointment, and threatened me, saying that you are not doing well by issuing notice to my wife, who is the managing director of Theme Creatives Private Limited, for the production of documents. Actually, your lordship, no notice was issued to the wife. Notice was issued to the director of your lordships, Theme Creatives. He received the notice and he suddenly came to the CBI office. I'll make you suffer for the using my contacts, as he was asked about his health condition pursuant to the request. When he intimated about his inability to appear before the undersigned in compliance with the direction of the High Court, he said, "You cannot do anything. Even I do not appear before you. I know how to manage the court and High Court." He's saying that I know how to manage High Court, your lordships. If you report anything against me, I will also make false complaint against you, like I did before the special CJM CBI previously. Your lordship, how can you dare to say things like that, your lordships? Repeatedly he is doing it. And your lordship wanted the IO to be present.
1 minute. This diary entry is made by the same IO who is appearing here.
Yes, sir.
Yes, Mr. Pradhan, you tell me.
Yes, your lordship. He's there, your lordship. May kindly ask him. He's virtually present, Mr. G. Khan.
Sorry. Yes.
Sir, right from the day he's out on his bail, sir, he's continuously threatening not only me but also many witnesses, sir. And one witness has filed some complaints against him. That also I have submitted, sir. And he's continuously saying that he has managed Honorable High Court and nobody can do anything to him.
Yes.
Sir.
Who is appearing
And,
for the opposite party? Who is appearing for opposite party? Number two. Let's see.
It's not.
Who is appearing?
Your lordships have made it very clear that no further adjournments will be given.
Yes, I have made it clear last time.
Nobody appearing, madam. Perhaps, my lord.
Notice your other issued or not.
Nobody appearing.
Appear who is the counsel?
I think they are not interested to pursue the matter. Your lordship may kindly come to page 40 to 41 of my Sudhanshu Sekhar Patnaik, your lordships, is a witness. Your lordships, page 40th advocate was appearing. I don't remember his name. Some Lalit. Let me check, your lordships. Lordship, one GK Mahanti was appearing in one IA. Gopal Krishna Mahanti. He was appearing.
The opposite party number 2 has already got the bail. We are looking at cancelling the bail. Okay.
Yes.
So he need to be here. We'll just check it up whether he has already appeared or he has not appeared.
Your lordships, here.
This is a case prima facie. I think the bail should be cancelled. If
Yes.
he is indulging in threatening the witnesses and the IO even.
Now, how can you tell that, your lordship? Your lordship, how can you tell that I know how to manage the court?
Mr. Naik, the problem is nobody is has entered appearance so far.
No,
It is a cancellation of bail unless the other side is heard. I can't cancel the bail like this.
Your lordship may kindly see the past orders, your lordships, because I think your lordship somebody had appeared. If I remember your lordships, one Lalit, the advocate, I don't remember his good.
No one has.
Your lordship, may kindly see the earlier orders.
Your lordship may kindly have a look at order dated 6/4/2023 by Honorable Justice S.K. Sahu, your lordship.
Yes, I can see that.
Yes,
Mr.
lordship.
Manoj Kumar Mishra, senior counsel, is appearing.
Yes, your
But
lordship.
unfortunately, there is no wakalatnama. Manoj
Yes,
Kumar
your
Mishra can't file wakalatnama.
Yes, your
Who has instructed? This is the funny way of.
That means
Yes, your lordship.
in this court
once
we are
Yes,
yes,
seeing.
your
Senior
lordship.
counsel without.
Right. Yes.
Without.
Your lordship.
Instructing counsel.
Yes, your lordship.
Your lordship, once the senior counsel has already appeared, that means that the accused knows about the fact that the case is listed and he has this.
Maybe, but somebody has to, counsel or not, record has to be there. I can't cancel it like this because some senior counsel who has instructed him, nobody knows it. And
Then you're not-
unfortunately, our proceedings are being written like this. This is the practice of this
Lordship-
court. What to do?
Your lordship,
When
as
senior
far
counsel appears, instructing counsel name has to be there. Who has
your lordship, as
instructed
your lordship, as far as I remember, I just lordship, I think Mr. Lalit Mishra appeared.
him? His name is not there. His wakalatnama is not there. How will I know?
Then your lordship, if the senior has appeared, your lordship makes. Lordship may put it at 2 p.m. I'll inform him.
Yes, that would be better. Let him come.
Lordship,
Somebody
lordship may.
has to appear. Somebody has to file wakalatnama. Otherwise, I can't cancel it. The bail which has been granted. Put it at 2 o'clock. I'll take it up. Okay.
I'll inform your lordships. Yes,
Please inform. Okay.
oblige your lordships.
Pardon, my lord. Item 62, just pass over.
No, not in between. Not in between.
My lord, kindly pass over the matter. I will.
Not in between. Whatever has happened, you come. There should be some discipline.
Yes, ma'am.
If there is a very clear indication at the top of the list, you should have come. Yes. Wait.
67.
No adverse order will be passed. Don't be sure. In the absence, I don't pass.
Similar putting.
Please wait. Please wait. Don't come under the,
67,
present
my
from
lord.
advice order will be passed. Don't do. Yes.
16 state filed this application, my lord, for cancellation of bail, my lord.
Hmm.
Notice already issued, my lord, to OP2, my lord.
Bail granted when?
Bail granted, my lord.
21 bail
My lord, my
granted. Why, what cancellation?
My lord, that reason, my lord, for that reason, my lord, your RCB issued notice, my lord.
Hmm.
Notice already, my lord, gone to the opposite party on 2, my lord. Nobody is appearing, my lord, another given, my lord.
Requisite for issuance of notice to the opposite party filed late.
My lord.
Be accepted, office is directed to proceed. देखो ना वो, हाँ? What is the ground of cancellation?
Cancellation, my lord, that there are 2 to 3 grounds, my lord. First, my lord, this honorable court directed him to appear before the IO, my lord. He has not appeared before the IO. And also, my lord, not hand over the seized articles, my lord, dowry articles, my lord. All the conditions, my lord. He also terrorized the witness, my lord. All the 3 conditions they have violated, my lord. And till yet, my lord, the petitioner has not got the dowry articles, my lord. For dowry articles, my lord. And the condition of paragraph 6, my lord, he will appear on 11/4/21 for seizure of dowry articles of the complainant at Hyderabad, my lord. He has not appeared before the IO or not, my lord, available there, my lord. Second, my lord, he has not terrorized the complainant. He has also terrorized. For that reason, the case are instituted against him. He also not cooperate the investigation for a completion of investigation, my lord. All 3 conditions he has violated.
Right.
For that, in notice.
The notice to the opposite party number 1, huh? Opposite party, number 1 is awaiting. Service is awaiting.
What is the 1,000 asked? How do you?
Get into next week. Service awaiting. Next week. 68. Yes.
On behalf of Madam Jana, may kindly pass over.
Pass over.
My lord, I am appearing for the OP2. I pray, my lord, I will not available at 2 p.m. Maybe taken out tomorrow or next week.
No, what is this matter?
A cancellation of bail. It is bail granted in January 2022. I have also filed counter.
What are the grounds?
The grounds, my lord,
What are the grounds, man?
ground.
He involved in similar type of offense.
He got bail in 2022, January 22.
Well, no, the allegation is that after releasing on bail, I was threatening the witnesses, my lord.
What
And
are the offenses where you got the bail?
that is 302, my lord.
354 to 90 of IP.
And in that case, after releasing on bail, they have filed a FIR. And in that case, I have acquitted. I have filed the counter affidavit to mail out that judge copy.
The FIR which was lodged subsequently.
That was in that case compromise and acquitted. Yes, ma'am.
Taken up after 81. Madam Jana will.
He is not able tomorrow. See, tomorrow. I'll not cancel the bail. But if you want some condition to be imposed, further condition, we can think of.
Further
See, January 2022 bail was granted. The trial, he must be participating in the trial.
Yes,
Why
sir.
to cancel bail at this stage?
Well, I have
And
to.
the case which you have, it is filed against you subsequently. In that case, he has already been acquitted.
May kindly taken up tomorrow.
Next week, your lordship, may kindly.
No, tomorrow.
My lord. My lord, okay.
69.
Kindly pass over the.
69.
Not pass over, my lord, I will not be available.
What is this matter?
My lord, here, my lord, offense under section 376. The victim appeared before the court and have stated that the petitioner has not committed any offense. Basing on that affidavit and personal appearance, the bail was granted on May 22. After May 22, there is no allegation. The informant is a, your lordship has already gone through, my lord, about this fact, my lord. She is a secretary of a committee, my lord.
So now asking for cancellation.
She is asking, not victim nor any of the relation. And 2 years back, the bail was granted.
Why to cancel it this?
And the age of the And in the age of the accused, my lord, 70, more than
Whatever
70.
now, wrong, right, whatever, he got the bail. He is not acquitted. Got the bail, he is facing the trial. If you have a good case, he will be convicted. If you don't have a good case, then.
Informant is not belong to the victim's
Bail
category.
matter, why unnecessary? Unless it is very, see, if you conceal some material fact, something, we will impose some cost or something, or some condition to be imposed. Once bail is granted, generally, no, not fair to.
Because there was a dispute between the two groups.
Whatever, I don't want to get into the merit, because I am not deciding this, only cancellation. Cancellation on the ground that he is involved subsequently in some case or whatever. I'll impose some condition if you want. Or you go to trial court if adequate conditions to be imposed, it will be imposed. Why to cancel the bail?
Learned senior Mr. Aniruddha.
Tomorrow.
That's
If he is not available today, tomorrow. Well, dispose it up. You think
Yes.
over it. Yeah.
Right.
Yes.
70.
Yes, I am for the petitioner. Cancellation bail bond and under section 376, I have been threatened from the release of the court. So opposite party number 2 has issued the notice on 27, I think. Cancellation bail bond, and when you have released on bail, 27 April, sir.
Services on opposite party number 2.
Already I filed it.
Nothing is there, my lord, that notice to P could not be issued due to late filing of the requisites.
You have not filed the requisites.
Late file, late file.
Hmm?
Late file the requisites for which notice could not able to serve, send.
The counsel for the petitioner filed the in pursuance to the order dated 27/6/2024. The requisites has been filed by the petitioner belatedly. Therefore, the service could not be effected on the any process has not been issued by the registry. The requisites may be accepted and follow-up action may be taken for the purpose of service. Yes.
71.
This may please your lordship. Your lordship, the appellant number 1, Kalicharan Mahapatra, is dead on 6/3/2013, and Pradeep Kumar Mahapatra, his younger son, wants to prays to be substituted in his place.
This
And
is an appeal against conviction.
my lord,
The where is that application, madam? Application?
pardon, my lord.
Application. Which application?
Application is at flag D, my lord.
Flag B.
D.
D. For
My lord, copy of the same to be served on me. They have not served the copy of the substitution.
Give a copy. I'll allow this.
My lord, the other two miss cases may kindly be. I'll not pressing, my lord. There are two.
Which are
Gote which is 6/75/2013, and there is another one 5/93/2013, which has been.
not pressed for this. And insofar as 1328 is concerned, madam, in 1328 you have written wrong provision of law in the application. It's not 482 CRPC. It should be.
My lord, I actually
394.
so there were I was not even.
I'm ignoring it. Just see the top heading 482 CRPC. You written.
My
That
lord.
should be 394.
My lord.
The counsel for the petitioner submits that the sole appellant in appellant number 1 or how many appellants?
There are two appellants, my lord. Appellant number 1.
Appellant number 1. Kalicharan Mahapatra is expired on
6/3/2013.
Therefore, the present application.
2013, my lord.
2013. Therefore, the present application is moved by his son to continue the appeal under section 394 CRPC. For the reasons stated in the application, the same is allowed. Consolidated memo
My lord, they have not served the copy. I will file objection because so far as this is a confiscation final order.
Confiscation?
Yes, my lordship. There is no provision for substitution.
Oh, I see. I asked she says
Yes.
conviction.
My lord, there is no. No.
Then it's not 394.
Yes,
right?
my lord.
482 394. That's what I was wondering. You said conviction.
My lord, unfortunately, I have
file
tried to
objection.
find out the case, but more the file.
Sir is there just guiding you.
of the act says that the provisions of the CRP.
Yes, I will file objection. My lordship, I will argue the matter. I will file.
Let him file objection.
Yes,
My lord,
Issue notice for the second issue notice. And she will file. Okay, reply.
My lord.
It takes week. File a small. Give a copy.
My lord, I'll give the copy. Obliged, my lord.
My lordship,
First two applications, not first. Okay.
my lordship, matter will be fixed to next week.
Next week.
72.
Rather, instead of conviction, 394,
394.
confiscation is more important because the properties are in.
Yes.
It can't be remedied. Somebody dies, his property and
Yes, ma'am.
family members can't contest it. Yes.
72.
This is
In the
appeal.
last occasion, my lordship, nobody was there, despite your lordship's past over and the repeated call, man.
When the matter was taken up on 22, sorry, or 2/7/2024, the following order was passed. On that day, on that day, none had appeared for the petitioner. Today, when the matter is called up, none appears for the petitioner in view of his name. None appears. Therefore, the petition is dismissed for non-petition. Yes, next.
73.
73, lordship.
Later,
Orders may be.
hearing list, ma'am.
It
is ready. Paper book has been
Lordship.
Let it be added.
Which year? 2000?
2015.
15.
Oh.
Let it be added to the hearing list.
Seniority list. Weekly list.
Weekly hearing.
Weekly.
76.
73.
Serial type.
Serial.
74.
It is added in the weekly.
Yes, weekly.
Obliged.
Seniority.
Item 74,
Hmm.
in the first sub-item, the sole appellant died, my lords, during pendency of the proceedings. And I filed a petition for substitution along with a petition for condonation of delay. To that, my learned friend has filed an objection, my lords, wherein he says that the petition is not maintainable, legal heirs have no locus standi. Now, my lords, I believe a reply to this objection is necessary because I find that my learned friend believes that we are without any remedy in these cases. So I'll file a reply. Your lordship may give me 2 weeks.
2 weeks. There was 2 weeks time to file the reply to the objection.
Yes.
Reply to the objection filed by the respondents. 2 weeks granted. After 2 weeks, huh?
75.
Now, how many appeals are there, Mr. Ponda? 1, 2,
There are
3.
4. Each of the delinquents have filed appeals. One of the delinquents died.
Okay.
My lord, item number 72, may I pray for 3 copy of the order? 3 copy of the order.
3 of. Yes.
75, lordship, they added the hearing list, 2018. Okay. Paper book already.
2018.
Mr. Niranjan Maharana's name may kindly be reflected and it may be added to the hearing list. Registry may be directed to serve a copy to Mr. Maharana.
Where is Mr. Maharana? He is not there.
Maharana is in court number 2. Okay. Old building.
76. Weekly is there.
Registry may kindly be directed to
Directed to supply the copy to Mr. Marana.
Mr. Marana, yes.
And his name may be reflected. Yes.
76. My lord, 76 is coming again and again, and the noting is there. Your lordship may kindly pass the order that paper book may be accepted. It has been verified, my lord. Your lordship may kindly have a glance. Lord and counsel for the appellant number.
Paper book is ready and everything is ready.
Paper book is ready. Paper book has been supplied, and the noting, fast noting is there. Paper book, your lordship may pass order. Paper book to be accepted. So copy has been, paper book has been supplied.
Copy of the paper book has already been supplied. The matter is ready for hearing, released in the weeklies.
And also the sub item, my lord, the your lordship have again and again directed to ignore the same thing is being repeated. Your lordship may pass order that it should be ignored.
The
sub item 557.
Noting कौन ଅଛି there?
Noting bail ଆଉ sterilization ପାଇଁ ସେଟା already ହେଇସାରିଛି since long.
Realization of file.
18/5/23 ରୁ bail ଆଉ
the office noting in the cause list shall be deleted.
18/5/23 ରୁ bail ଆଉ file stay
Shall be deleted. Okay. ठीक. List, weekly list.
Weekly hearing list.
Seniority wise.
Okay. 78.
What happened to 77?
78.
Yes. Yes, sir, 78 revision.
At 78, requesting for a password on behalf of Mr. Sangram Das. 78, 81 and 84. 78, 81 and 84. Requesting for a password.
Who is appearing?
Mr. Sangram Das will be appearing.
Sangram. 78?
81 and 84.
Okay. 79.
79.
I beg pardon, 76, may I pray this matter be taken up next week, on behalf of Mr. Kanun. This is a vigilance matter.
Revision.
76 has already been directed to be listed in the hearing list.
I understand,
Next week,
there's an
what-
IA, what I praise, there's an
Let
IA.
it will be there in the weekly list. You mention it. We'll take it.
I'm grateful.
Yes. 79 we are in 79, no? Yes. This is against what, sir? Unnecessary the matters are pending. Leave the matter, leave the matter. Keep it outright. Keep it outright. This is regarding what? Nobody appeared.
Private parties, my lords. Both the parties are private parties. Might be 138.
Private parties. Password is otherwise will dismiss. Nobody. Password, no?
Item 80.
80?
Correct.
Yes. 80. Yes.
Item 80.
The defect is not removed.
Hmm?
Defect was not removed. It was nothing.
This is what?
This is a conviction under section 324 and 447. 6 months rigorous imprisonment and only
Offense?
6 months. Offenses minor 324 and 447. Assaulted by means of sword and sword. was seized
Convicted by both the courts. Defects are not cured, huh?
Defects are not cured.
Defect, I beg your pardon. Item 80.
See, 2015, 13 you have filed.
One.
And this is only 1 decade. You have not cured the defect. And you still, are you interested in this matter?
One.
2030.
My power is there, my lord.
Then I'll impose cost, you both of you share and give it to us. You are a former leader of the bar and the present leader of the bar. I'll impose 10,000 cost.
Ignore my lord, defect, ignore my lord.
No, I'll ignore defect and everything, but 10,000 cost, the former secretary and the present office bearer has to bear equally and pay to the bar. What is this? 2013?
Next week, sir.
Infection not cured. What is
She will have to, my lord.
Next.
tomorrow?
Mine.
You come tomorrow prepared, defect ignore everything.
Mine.
Get ready and come
6
tomorrow.
months conviction, you don't see this was.
Mine.
Ah, that's what I'm saying.
Mine.
This was, shall I dispose it up right now?
Yeah.
I'll
After
give you,
lunch. After lunch.
I'll give you PO and finish it up.
Mine.
Provision of
Yes,
offenders
ma'am.
act and finish it up
Yes, madam. After lunch.
after lunch. Okay.
Mine.
Defect ignored and argue whatever. If you think that it is a case of acquittal, just go through and tell me. Otherwise,
Exactly.
conviction maintained and PO.
Mine.
Okay,
Okay.
with some cost. Yes.
81.
This is that matter, last hearing it was there on my lord's board.
Yes, sir.
With regard to that excise fixation of NGQ matter.
Yes.
Which is virtually covered by Honorable Supreme Court judgment, the order. In a nutshell, quickly I'll tell you, Lordship, what's the
Who
problem.
is appearing? Mr. Das. I think.
Malas, I have requested for a passover earlier. This item 81.
Passover, my lord, but today I'm very badly placed, maybe tomorrow.
Tomorrow.
Yes,
Let it be tomorrow.
Yes,
Let's see.
no issues.
So kind of.
Every day you are badly. That's the whole
Lord, I arrange my blood in terms of these items.
I'll take little early. In the sense, first hour, we'll try.
Thank you.
If you can come at 2 o'clock also, no problem. Today,
2 o'clock
you just
hobo.
think over
Kali hobo.
tomorrow.
Okay.
Tomorrow,
So
2 p.m. minutes?
2 p.m. tomorrow?
2 p.m.
2 p.m.
Minutes.
So grateful.
Interim order and 84.
82 also you need.
84, my lords. 81, 78, 81, and 84.
Okay,
So also 62.
that's all possible.
Yes.
Yes, sir. Then I'll do what I'll do is I'll come after 5 minutes. That's a better idea.
My lord,
Better
item
idea. Let it come. Instead of asking.
81
I'll
interim
just
order.
come
to
after just 5 minutes. Mr. Das will also be coming. Yes,
And that's in item 1,
1992.
92 matter, your lordship has directed the State Council to take instruction from IIC Bariguma Police Station. In fact, earlier,
Year 1992,
yes, ma'am.
he was 63.
Yes.
So he must be
96.
96.
Because earlier we did a local inquiry in December 23, we will not able to trace the whereabouts. So that is the reason your lordship directed Mr. Ragra to.
Yes, Mr. Raghuda. 1992, he was 63, means 96, 97. Satrapur Police Station and Borima Police Station.
And it comes day after tomorrow.
I see the last direction is 24/6/2024. I have given direction to the
Yes.
Boriguma Police Station and Satrapur Police Station because he has given 2 addresses.
Yes.
So verify it. You have not got any.
The office must have been communicated, my lord. I'll take instruction and
Tomorrow?
Day after tomorrow, my lord, I personally, my lord, talk to the.
Up to day after tomorrow. Day after tomorrow. Land Counsel, Mr. Ragada, Land Counsel for the respondent submits that pursuant to the direction dated 24/6/2024, he has not received any instruction, leaves the matter on day after. Yes.
Item 2.
He might have died by now.
I personally.
Yes.
Item 2.
Item 2.
My lords, in
this
item
case,
2, I have received the instruction from the concerned SP.
Yes.
He is no more, my lords. He has expired on 25/8/2021.
No, there are 3 appellants. He means who?
My lords, item 2, I'm in item 2.
Item 2.
Yes, ma'am.
Yes.
Only one appellant is there, Somnath Jena, 364 of 92.
No, sir. And 2 others.
My lords,
Just see.
my lord, I'm dealing with item number 2, my lords.
Item 2.
Yes, my lords.
Somnath Jena.
Yes, my lords.
And 2 others.
Yes, my lords. And 2 others.
Bhaskar Bhushan and Purushottam Acharya. I think they might have also died. See, Somnath Jena was 48 in the year 1992. He also died.
Yes.
And Bhaskar was 50. And Purushottam was 56. And 32.
And nobody has come up to file their substitution petition also, if at all. Can be disposed of.
I don't. Mr. Regional and Counsel for the opposite party submits that the 1 and 2.
Only one, that's Somnath Jena.
Name. Persons to the persons to the order dated 24/6/2024. The matter was taken up on 24/6/2024. The following was passed. Person to the aforementioned order, Mr. We got instruction that the applicant.
Some instruction from SP Vigilance, Koraput Division.
SP Vigilance, Koraput Division. In view thereof, the
A bit.
Yes.
Vigilance case, my lord, you have to directly need to take inspection. In fact, one of the address and not available with me, my lord. Since the file belongs to Vigilance, my lord.
You are talking about item 1?
Item 1.
Item 1.
I will share the address. Share the
address and all I have said deeper.
No, upon day.
So next week, just now.
Yes, just now I will give. Item 1 to the answer.
So item 1 is for the day after tomorrow. You keep it Monday. Keep it for Monday. Okay.
I'll take the address.
Right now you give it.
Yes, I'll give it.
Yes. 3.
Item 3 we have sent for instruction. We are awaiting for that instruction, my lords. We have sent it on 28/6/24 after receiving the copy of the order.
Possibly dead because by the time of passing of judgment, he was 63. He was 95.
63.
Then your lordship may,
So I was.
then your lordship may record my minutes. Yes.
But let me allow him to obtain instruction because I don't. Nobody.
63 means now crossing 100.
100.
Crossing
Yes.
100.
But I can't pass the order on the basis of
No,
some.
Ballot.
I have put up somebody's.
Let it come on then 18th, my lords. Other matters are fixed. 18th. Let it come on.
No, make it 15.
तर तेवढ्यावर फोन किती नाही की कसं बने address भी से ठीक है.
15 कर दिया. 15. Simply 15.
Item 4.
To seek instruction.
Item 4.
Let us see. This is item
4. Madam.
No. 3 na. Sir is appearing in item 3 na. I click this na. Click it.
Item 4 also. 4.
4 malice I have received the instruction.
And direction was already given to Parampur Vigilance.
My lord, I have received the instruction.
What is that? 3.
It's 3.
Item 3.
My lords, 3 I need some time, my lords. 3 has the lordship has posted to 18th, my lords.
No. Why direction was given? Why
My
Vigilance?
lords, I have sent that order copy on 28/6/24.
15th then. 15.
15th.
Yes. And 4?
4 my lords I have received.
Yes. What is that?
His etc. share. He retired on that. He is now aged about. He is alive, my lords. He is now 81 years old.
Huh?
He is alive, my lords.
So we can do it, and this can be done.
And is suffering from aging problems. What is it?
Right.
Yes.
What is the age?
Age 81 years as on date.
81. So at least this is conviction, huh?
My lords. We tagged in the weekly list.
Is there any chance of acquittal?
It can be converted to fine matter because I was going through the brief. Here is a case ballot. I've gone through.
No, I have not.
It's a case ballot where while he was supervisor of a forest division, around 16 coupes were there under his
Provisional.
16 coupes. And it is alleged that he handed over the charge to PW4. PW4 says, I have not received the full charge. And ultimately it was, a case was registered on the basis of an information lost by the Inspector of Vigilance. That some logs which were stamped and it was kept in the coupe, that was found missing. This is the allegation. And cost of the firewood and the logs will be around 1,10,000.
Convicted under which provision?
On section 5
409.
and 409
5
of the old act.
5(1)(c) and 5(2)(d).
My lords are holding the new act, that old act, my lords,
Old
1947 act.
Old act.
That the Xerox one.
Photocopy he has given, na?
47 act.
Xerox copy नहीं निकाले थे आप उस दिन वो वाला.
मिनिमम सेंटेंस कितना है? फाइन है तो फाइन
Minimum-
खत्म करो 81 है.
हाँ ठीक है सर,
हाँ?
कोई दिक्कत नहीं.
Conviction maintained and fine करके
कोई
खत्म
दिक्कत
करो.
नहीं सर.
Fine नहीं.
फाइन तो नहीं है सर इसमें. There is no fine, only 3 years conviction.
No, 5,000.
That's right, but let us see the minimum.
Minimum is 1 year.
1 year.
As far as I remember, 1 year to.
And PO also we can't give in PGL. देखो, keep a old act also here. Today itself. Get old act.
Less than 1 year, not less than 1 year, but which may extend to 7 years.
What to do?
Period already.
3 years was given. 3 years was given.
Has he undergone sometime?
Must have, yes.
Just
Must have,
take it
must
up.
have.
1 year he has
1 year,
undergone.
yes.
Must have gone some period.
Let us see. Let us see, sir, if you can.
Valid.
Who is your instructing counsel?
Next item is 5 valid.
No, this instructing counsel,
Instructing counsel, valid.
he has to check period undergone.
Period undergone.
I'll verify for the records valid here.
LCR में मिल जाएगा.
Shall I put it for tomorrow?
Tomorrow, valid.
We should put it for tomorrow. Let us see.
Valid.
Undergone, if he has undergone
Some period.
about 6-7 months also.
6-7 months हे नव्हतं outpoint.
Or very less, not that.
तर तेवढं अरेस्ट करून नव्हतं
ना.
PC Act.
Do you have any judgment where in the
Then valid next week I'll see.
and
Where-
that will be a great help if
Valid,
somebody is at the fake
At the
end
flag end of his
life.
life.
Alive, yeah.
Flag end of his
Can
life.
the court modify the sentence
Valid.
despite minimum
Valid, valid,
sentence?
valid.
If you can get that
Valid,
you
valid.
employ and all the matters we can dispose it.
Valid.
Mr. Rijvi also see.
Minutes.
If somebody is 80 years,
Yes.
sending, see, we are following the reformative.
Reformative mechanism.
Get some judgment, we'll quote that and maintaining conviction, we leave all these people.
Minutes. I will check it out.
Those who have crossed 70, 75, all these matters we can dispose it up by modifying the sentence.
15 plus 12 plus.
15th was.
12th. Yes.
12th. Let it be on 12th. Huh? Please get some judgment.
I will try.
Yes. Next.
Matter 5.
5.
Yes, sir.
What instruction?
Anything? Superintendent Koraput.
Matters.
I had written a letter. My letter was returned back. So I contacted the local lawyer.
Because they have done an local inquiry, but they failed to ascertain the whereabouts. None of the residents couldn't say anything about this appellant.
Indri Ramakrishna.
Yes.
What was his age?
He was valid. 31.
Let's see what was his age.
The age will occur.
Nowhere it is found mentioned. That's the problem.
Charge sheet.
No, his statement just see. His statement.
Statement will be 9.
Statement will be 9 was said.
Verify costly 9. Is it about dash here like I statement? Judgment will be 9.
Get you. This thing very difficult.
LCR LCR
I'll just check it. LCR. This is 5, na?
I verified.
I'll just see the LCR. He's charge sheet.
So that's 87 case.
$85 he was working. Sindri Ramarao, no?
Yes, ma'am. Sindri Ramakrishna Rao.
He was 44 years. At the time of filing charge sheet.
In the year 85.
On,
Charge sheet was
year
submitted
1980. 89. 89, he was 44. Now, count.
Substitution.
79.
79
years.
70.
79.
80 around.
What to do?
The decision to the receive points is
Put it on 12th. Get that judgment is covered. We will. What is the what you call conviction under which provision?
Say 5-1.
Same mallards. 5152 mallards. And 409.
Get some judgment.
And
And all these matters could be en masse. We
Yes,
can
yes,
discuss.
mallet.
Yes.
Item 6.
In 2003,
And this last time
he was
someone-
45 years.
No. This last time somebody appeared in this matter.
Early hearing.
Whereas here paper book maybe, no, paper book is available, yes.
Somebody moved an application for, petitioner moved an application for early hearing,
Well,
but in the last date of hearing, nobody appeared. What is this case is about? Let us see. Conviction under which provisions?
it's conviction under
32.
7.
7.
7 trap case.
Sentence?
Allowed RI for 6 months and fine of 2,000.
Fine 2,000.
Yes.
7. Old age?
New act.
New age?
88.
What is the minimum sentence? But the problem is he'll lose his pensionary benefit and all.
Yes. Those are the ramifications of
That
convictions.
ramification is there. What to do in these kind of cases where you file an application for early hearing, you don't come. Pass it over, let us see.
Minimum is 3 years. Once.
Minimum is 3 years.
3 years to 7 years.
Yes, next. Pass it.
Item 7.
Olga, okay, password.
Yes, Mr. Dei. You short time, last time you are keeping quiet now.
9, item 9.
No, we are on item 7.
Item 7,
Item 7, my lord.
you short time on behalf of Mr. Das.
Yes, let's see. And,
What to do?
don't contact the Mr. Das, let's see, pass of that after recess.
This is also conviction.
Yes, once.
In short time, I corrected.
Paper I have not received, madam.
You are for?
I am for second case, madam.
Rajkumar Jindal. There is only one paper book. In one paper book, both the appeals are tagged together. Xerox
But you
table.
collect the paper book.
Yes.
List it in the weekly. Collect the paper book. Yes.
First case, my instruction is the accused has passed down.
That you that's the important information you got. Right on. Let it consider. So item record.
He was Tahsildar.
So item na Rajkumar Jindal.
No,
Yes, died.
Yes, no.
No, first case he is saying. Gananath Dandiya.
Dandiya.
CRLA 100 of 2003.
100 of 2003.
He was Tahsildar. He was Tahsildar of that time.
Land Council for the petitioners submits, appellant submits that the sole appellant in this case has expired on. Expired in view of the same, the appeal stand debated. What about the second one?
Second one, I say, my lord, some day, I will collect it.
Rajkumar Jindal.
My brief has been misled. I am trying to reconcile the brief, my lord.
See, in 2003, Rajkumar Jindal, na?
Yes, ma'am.
There are how many? Two
appellants, man.
Two appellants.
Rajkumar Jindal was 60 years. And Kashmiri Lal Jindal 70 years. In 2003.
My instruction is Ali, man.
He said.
Both of them.
My local lawyer said he is Ali. Rajkumar Jindal is Ali.
What about Kashmiri Lal Jindal? He was 70 that time. Huh? Both son of Pyarelal Jindal. You seek instruction. Learned counsel for the petitioner,
Appellant.
appeal 112, 213. Submits that at the time of filing the appeal in the year 2003, the appellant number 1 was 60-year-old and the appellant number 2 was 70-year-old. Therefore, he seeks an adjournment to get the instruction regarding the whereabouts and well-being of the appellant. Please the matter next week. Next week.
Okay.
Get instruction.
Fine.
Yes.
Item 8.
No, 8 my lord.
2003 matter. No communication with the petitioner. We send a letter next week. We send a letter to petitioner. Till then, no contact. Or reply.
He was 58 years
Yes, my
old
lord.
in the year 2003. Which area is this? Vigilance case, no? State vigilance case.
Keonjhar.
Yes, Mr. Rijvi.
Sambalpur division.
Sambalpur division.
Sambal.
SP Sambal.
At the time of 11 counsel for the petitioner, appellant submits that he has been trying to contact his client, but to no avail. He seeks an adjournment. At the time of filing of the appeal in the year 2003, the appellant was 58 years old. Therefore, therefore, Mr. Rijvi submits that he would seek instruction from the concerned
Vigilance division.
Vigilance
Division.
Regarding the well-being of the well-being and whereabout of the appellant. Appellant. This is the matter on 18th. By 18th, you also get the information.
Yes.
Yeah.
Item 9.
Copy there.
9, that's it.
Take the copy, you send it.
Yes, ma'am.
Yes. Yes, madam, 9.
That's it. Ready for hearing, that's it.
Ready for hearing?
Yes.
Weekly. Yes.
Today.
Weekly, because I want to give much 2003 matter. Let us see if I can pick up older matter, then I'll give preference, otherwise I'll take it. Let me go through the list first.
Yes.
Okay. Yes.
Tomorrow.
Otherwise,
tomorrow.
no, let it be.
Yeah,
I will
already written
yes,
note already.
You are ready, everything is
Yes,
ready, no?
yes.
I'll take it up. You are ready?
Yes, ma'am.
Offense under?
Offense under section 13(2), that is 13(1)(d) and the 7 of PC Act. The trial court convicted the presumption under section 20 of the Prevention of Corruption Act. That is the demand has not been proved. Demand has not been proved. Recovery is not, the appellant has not been recovered the money. That is why the small matter.
No, it's not that as simple as what my learned friend is submitting. And I will clarify everything during the time of hearing minutes.
Okay, I'll see. Just be ready. I'll take up the matter. Yes. Let me go through the list first.
Item 10.
10 nahi ki. And then 10 we need a paper book, my lords.
Paper book is ready?
Yes, my lords, there. Noting shares with
Paper
LCR
book,
and paper.
right, and paper book case is ready. Case is directed to supply a copy of the paper book to Mr. Rijvi, list in weekly. Weekly for give
Copy of the paper book.
Copy of
ma'am.
given direction. Yes.
Item 11.
Hmm. 11. Yes.
Misappropriation case, my lords.
Huh?
This misappropriation case, appeal against conviction, convicted under section 13(2) and 13(1)(c). 7,305 kgs of barbed wires amounting to rupees 69,000 some odd.
Non-APS for the appellant. In the interest of justice. No, he was see 2006. He was 60 years old.
Item 10, Lordship.
You also seek it, sir.
Lordship, item 10.
60 years means now he must be about
80 plus.
The non-APS for the appellant. It is seen from the record that at the time of filing of the appeal in the year 2006, the appellant was 60 years of age. In view of the same Ganjam, District Ganjam, huh?
Berhampur Division, SP Vigilance, Berhampur Division.
Berhampur is directed to verify the well-being and whereabouts of the appellant and place a report
18th
through Mr. Rizvi, counsel appearing for the Vigilance. It is released on 18th. Give it today itself so that he can send it.
Yes, ma'am.
Item 12.
Means 12, we need paper books, my lords. There are 3 appeals, my lords.
3 appeals, huh?
Yes, paper book needs to be supplied.
12, na?
Yes, my lords.
Item 12. No.
No, my lords. 12, only 12. Only 12. Only one appeal is there. Paper book is
yeah,
required.
yes.
12 paper book is required.
Paper book,
Yes,
ready, because he was 55 years old
Yes,
when the petition was filed. Nobody appears for the petitioner. Paper book in the present case is ready. Copy of Rizvi is directed to supply a copy of paper book to Mr. Rizvi, listed weekly. Yeah? Yes.
Item 13.
13, my lords, paper book is ready. That needs to be supplied. Noting says with paper book, my lords. Noting says with paper book. So that needs to be supplied to us.
Who is appearing for the appellants?
Mr. Mund, his name is there. 13, yes.
13, 1-3. Huh?
Name of Mr. Santosh Kumar Mund is reflected.
Your name, see, Mr. Mund's name
Pramod
is
Kumar Mahanti. There are 3 appeals. In first appeal, I think Madam is appearing in the first appeal.
Yes, madam, what do you say? Tomorrow. Verify. Note it down and take it. Tomorrow.
Let it lie over.
Huh?
Let it lie over.
Lie over tomorrow. Huh? The same question. Let us know whether these matters are still alive or had died of his natural thing. Tomorrow. Which liquor country? 14.
Item 14.
2006, he was 61 years. Yes. 61, 2006.
Nice.
Let's see. One means
81. 81, 79. To precise 79, yes.
let's see which area.
This Cuttack division.
Cuttack division. Cuttack division. What of at the time of filing the appeal, in the year 2006, the appellant was 61 years. Okay. People is non-appeal for appellant. Vigilance Cuttack. Cuttack division. Through Mr. Rijvi. Out of 80.
Item 14, no? That's 14, no? That's 14.
18.
Item 15.
You send it.
Yes, madam.
For 18th, let us see 18th and 15th. We will see
how many instructions are coming. Then
otherwise, we will request the director.
okay, no, madam, they are doing their work. They are sending regularly. In 15th, lot of the matters will be disposed of. I have got a lot of instructions in between.
18th also we will do like that.
Yes.
Lordship, item number 15. It's a old matter. My lords may fix any other date for hearing.
2006 matter. You are ready?
My lords may keep it on any other date.
No, I'll keep it, no problem. Are you ready or not?
Yes, ma'am.
Ready with this matter?
Yes.
Okay. Let them counsel for the. I'll put it in the weekly list. Get ready. Okay. Yes. Weekly list. Okay.
My lords may put it on 30th. My lords, maybe.
It reach after 1 week or 2 weeks. No problem. Okay. Appearance law is followed.
Yes.
Item 16.
Yes, sir. Non-EBS for the appellant when the matter is called up. In the interest of the made clear that EBS the court will proceed with the appointing MAK school, non-EBS.
This will live or not?
No. Last time none appeared, so therefore there was an indication that if nobody appears, then
amicus, yes.
Amicus. Mr. Dey is overloaded. His office is also overloaded.
Yes.
You suggest someone. You suggest. Mr. Rijvi will suggest someone.
Yes.
By order dated 26/6/2024. We can appoint Mr. Chinchani.
Yes, madam.
Sir's friend.
Yes.
Mr. Das.
Mr.
Chinchani.
Mr. Chinchani. As amicus.
Pratap Chinchani.
I will
He can inform because he is very.
No, I know.
Very effective assistance. We can.
Agreed.
26/6/2024. Following order was passed. When the matter is called up today, none appears for the appellant. Therefore, this court appoint Mr. P.C. Chinchani, advocate at MAK Security to assist the court. Please, the EC is directed to supply the copy of paperwork to Mr. Chinchani. Please the matter.
My lords are calling this matter.
Give it to Mr. Das so that he will inform Mr. Chinchani.
My lords are calling this matter on minutes. Taking up this matter, my lords.
We'll put it in the weekly list.
Next week.
Matter.
From next Monday onwards.
Next. Please, weekly. Supply the copy. And Mr. Das will inform. Yes.
17.
79.
Yes.
17 minutes paper book needs to be supplied. Paper book is ready. Copy may be given to us.
The same thing. Last time nobody appears, and it was given indication that same order could be Mr. Chinchani. The matter was taken up on 26/6/2024.
2 matters.
This order was passed and see last year got a change. In both the matters, because
Yes.
same issue.
This paperwork may be kindly supplied.
Paperwork, same order.
Matters.
Paperwork supplied to. And tell him so that one day he'll come prepared so that we both the matters we
Can be
can.
discussed.
Whenever you please inform him, let him take the copy, get ready and come and mention.
Yes.
And prior intimation to
Yes.
Mr. Rijvi, we
Dispose
finish
it
it
up.
up.
Yes.
Yes.
Item 18.
18 Millers, I may be pardoned to appear through VC Millers. Plus, I am held up in another court, Millers. This is a trap case, Millers. As of today, Millers, the appellant is of 77 years, Millers. I need to take instruction as to whereabouts and well-being of the appellant, Millers.
He was 59 years in 2006.
Millers, Millers, as of today, it would be a 77 years, Millers.
Yes. Right on, Mr. Sarma, Learned Counsel for the appellant, submits that at the time of filing of the present appeal in the year 2006, his client was 59 years of age. So therefore, therefore he seeks 1 week adjournment to get instruction regarding the whereabout and well-being of the appellant, least the matter. And least on 18.
Millers, may I request one thing, Millers?
Yes.
Millers, may I request one thing, Millers?
Yes, yes.
Millers, if my learned senior Mr. Rizvi also can take instruction with regards to send handwritten letters. We do not have contact numbers, Millers. So for that,
This vigilance, which vigilance, this thing, division? Barampur.
Barampur.
Mr. Sharma further submits that the state may be directed to also seek instruction regarding the well-being and whereabout of the appellant. Accordingly, the SP Vigilance Barampur Division is directed to locate the submit a report regarding the well-being and whereabout of the appellant and leave the matter on 18. 18.
Yes, Millers.
Okay. Yes.
I'm grateful, Millers.
Yes. Same story here, 60 years. Non-APS for the appellant. It appears from the record that when the present appeal was filed in 2006, the appellant was 60 years old. Therefore, the well-being and whereabout of the appellant needs to be ascertained. Accordingly, the state, accordingly, which area is this?
Barampur, Millers.
Huh?
Barampur.
Vigilance, Barampur?
Yes.
SP Vigilance Barampur is directed to directed to
ascertain the well-being.
Ascertain the well-being and
whereabouts
of the appellant and file a report through Mr. Rijvi, Learned Counsel for the list on 18.
Item 20.
20 Lordship, weekly list, ma'am. 20. 20 weekly list, ma'am.
Sorry?
Ready for hearing.
Ready?
Yes.
Weekly. Weekly report. Yes.
Item 21.
Might not kindly pass.
What pass over first? Let us see.
My senior is in another.
You are for?
Petitioner, Upendra Pradhan.
Upendra Pradhan.
Upendra Pradhan.
Appellant?
Yes.
1 minute. 2006. 61. Password? Password.
22.
22 Lordship, same day. Ready for hearing, weekly list.
Ready? Weekly done. It's
Password.
the appellant is alive?
Yes, Lord.
22 due.
Yes.
23.
All of your clients are very strong. Even in 80, they are Still alive. Yes.
23.
Yes.
Minus 22 will be going the weekly list. Ready for,
Weekly.
yes.
Weekly. And let us go through the entire list so that we can get an overall idea what
Idea.
is exactly happening.
Exactly, yes.
These matters are pending from years and years. And the councils are also not in touch. That's the problem. See, in this matter, this is 80, sorry,
23.
23.
2006.
Last time it was taken up in the year March 2019. None appeared for the appellant. Thereafter, matter is like what? None appears for the petitioner. Lastly, when the matter was taken up on 8/3/2019, none had appeared for the appeal. In the interest of justice, she had changed the matter to next week for the date review. It is made clear that in the event none appears for the appellant, this court will proceed with the matter by appointing the amicus curiae. Next week, the amicus curiae appointment. Rest, yes.
24.
24, that's it.
3 matters.
24 ready for hearing, so hearing list continue to weekly list.
See, he was 60-year-old in 2007. First item.
Inform.
You must seek instruction, madam.
Lordship.
Have you seen it?
2 weeks after.
And in the sub-item, it is he was 62-year-old in 2007. Will you seek instruction?
2 weeks after, maybe came it 2 weeks after. In the meantime, I will inform instruction.
They appearing for the appellant, both the matters, huh? Appearing for the appellant submits that she would seek instruction regarding the well-being of the appellant within 1 week, huh? Within 1 week, least after 1 week, huh? Anytime.
25.
25 is alive. He is alive and will continue the list.
Ready?
Yes.
Weekly. Okay.
But in 25, a paper book may be supplied to us. Yes.
Paper book is ready?
Yes, madam, it's there.
Paper book in this case is ready. Registry is directed to supply a copy of the paper book to Mr. EGB. The matter is ready for hearing. Please, the matter in the weekly.
26.
26 so can be taken up in next week. It's also criminal appeals against Prevention of Corruption Act. It's a vigilance matter.
Madam, he was 59 years old.
And now around 75 years old.
He is alive.
Alive.
Paperwork, everything is ready.
Paperwork is ready, ready for hearing.
Though I'll put it in the weekly list.
Yes.
Whenever it comes.
Paper book be supplied to us now.
Paper book, same order kar do. Paper book, huh? Paper book order kar do. It's ready. That is directed to supply copy of the paper book to Mr. EGB.
Paper copy has been given.
Okay.
27.
27.
And in 26 there are 2 matters, huh, madam?
Yes,
There are
madam.
2 matters.
Second one is TCRL. That's in government appeal.
Okay.
7.
Ready for hearing.
The demo.
Maybe I will list 27.
It's ready for hearing. Paperwork and everything is ready.
Yes.
Weekly report. Okay.
28.
Pass over, madam. Pass over.
29.
Pass over. 29.
29.
29, my lord.
Yes, sir.
At the time of filing, he was 55. now 72 or 71. And
You know, it's
and no instruction. The phone number which was provided at that time, I called him.
So
but
which area this is?
he-
Vigilance?
Well, sir, I'm not having the paper book or any record to
Do you
that.
have a paper book?
No, madam,
No.
I don't have.
paper book has not yet
No,
been
but
prepared.
impugn order, just give it to Mr. Rijvi so that he will locate it. Give that copy to Mr. Rijvi, one copy. Detailed, unless you give, how will you get? At least copy, give that.
No, copy
I'll
has-
put it tomorrow, get a photocopy and give it to him so that we will try and to locate the whereabouts of the gentleman. Okay?
The man is from Puri.
Sir, unless you give the entire setup of the papers to Mr. Rijvi, he can't send it to the concerned
No,
people.
no, that's true.
Get a photocopy
Yes, yes.
and give it, I'll take it up tomorrow.
All right,
Okay?
all right.
So that appropriate direction can be.
Yes,
taken. Okay? Please do that. Maybe because tomorrow I will come, no? Yes, next. Item 30. 30.
30, my lords, maybe adjourned to next week. Paper book has not been.
You forget about paper book. Everything is there.
My
you
lords,
can take it from.
next week.
This is an appeal. See, he was in 2008, he was 60 years.
60 years.
My
He is alive?
My lords.
Alive.
My lords.
I'll put it in the weekly list and get ready.
My lords.
Okay, weekly list. 31.
31, right?
Yes, sir.
ସେ ବୋଧେ ବଞ୍ଚି ନଥିବେ କାରଣ 98 ବେଳକୁ 53 ହେଇଥିଲା।
No, 90, no. In 2008 when you filed,
ନା
you
ସେଟା
are writing 53.
ସେ ଯୋଉ ଜଜମେଣ୍ଟ ରେ ଯୋଉ ଡେଟ୍ ଏଜ ଟା
I understand. Judgment to 98 ray.
Right.
He was 53. When appeal was filed, 53 is written. But in fact, what to do?
ସେ ଯୋଉ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ସରକାର
Same, which area? You tell me.
ସେ ଥିଲେ ତହସିଲଦାର ଉମରକୋଟ ଥିଲେ at the relevant time।
So, Barampur division.
PS case is important. Which PS? PS देखो। FIR पर देखो।
This is revision of what?
No, no, this is appeal.
Yes, ma'am. The FIR there must have been an exhibit. So that it must
Before
have
the DSP Vigilance, Jaipur.
and Koraput division.
Koraput division. There is a division, huh?
Yes.
At the time of trial, the petitioner 53 trial name, but trial, the petitioner was 53 years old. And Mr. Mishra and counsel for the appellant submits that he must be around more than 90 years. Okay. Therefore, the SP Vigilance Koraput division is directed to obtain place on record a report regarding the wellbeing and whereabouts of the appellant and list him from 18th. 18th, let us 18th.
Yes, ma'am.
18th. Okay. 32.
Hmm? 32. Already been mentioned, man. It's in the morning. 32.
33.
Madam, here the paper book is ready. 33.
33. There is no chance. 1988, he was 72 years.
No chance.
Shall I dispose it up?
Yes, ma'am.
So 72 means how just 98, 90, 98, 88. If you see trial court judgment.
It's 19.
1988.
36. So what was his age?
Huh?
At that time, what was his age, my lords? Age
72.
And more than 104 years. my lords.
The problem is, I'll tell you, the one thing you must locate also. In the appeal paperwork, the appeal cause title, the age is written
Yes.
72. Whereas if you see the trial court judgment in 1988, the same 72. In the appeal, he might have written the same age, 72. But
Well, immediately
fact
after
of the matter is, he was 72 in the year 1988. Let us see.
After the judgment, he must have immediately filed this appeal. No?
Therefore,
So 72 years.
Let me see the charge sheet. In the charge sheet, we can very well locate. Charge sheet. Charge sheet is filed in 86. That time he was 49.
49.
The seat. Charge sheet they were filed in. Count. 49 years in the year 1986. No. Here it is.
87 years.
87. Then in 1988, how he is writing 72? All these things are dicey. At the time of filing of charge sheet must be the correct.
Yes, sir.
At the time of filing the charge sheet in the instant case, the appellant was shown to be 49 years old. 49 years old. Which area is this? Just see.
But this is item 33, no, that's
Huh?
33.
Which area? Vigilance.
Bhubaneswar, matters.
Bhubaneswar, huh?
Yes.
Kotak division.
Bhubaneswar division. matters.
Bhubaneswar division.
Yes.
Right. ASP Vigilance Bhubaneswar division is directed to verify the whereabouts and the well-being of the appellant and place a report for this court on the next letter here, 18.
34.
So the age of the appellant was 55 in 2008. Now 75, 76 in Iran.
75,
76. And also paper is ready. I'm ready to argue matter.
Argue. He is alive.
Alive.
Paperwork you have got?
Yes.
I saw the copy.
The matter is ready?
Yes.
Weekly. Day after tomorrow, will you tell me when?
Next week, yes.
Because he's 78-year-old.
76, 75, 76.
76. We'll hear it. Next week, anytime.
On 8 or 19th.
Let it be there let it be there.
Yes,
whenever we'll adjust it and hear it. Get ready. Yes. Retaining the priest. Yes.
35.
My lord, I'll take note next week any day, my lord.
Revision.
My lord.
Against?
Against vigilance.
No, revision against what? Vigilance department. State is filing. State is filing
Yes, state. Let it pass it on, that's all good.
Against charge.
Yeah, I think must have been acquitted. I mean, the discharge was allowed, not most likely.
No, in the prayer, if you see, where is that
I'll
order?
let it pass it on. That's all.
I'll just pass it over. Nothing survives in this matter.
Hmm.
See, this is pending to 2008
No, no.
regarding some charge or something. What charge?
They pass it on. I'll
Yes, 1 minute. I'll just let me understand.
Item 35. About the brief. 35. Reproduction.
They were discharged.
Huh.
They were discharged in the year 2005. He was discharged.
So I today, in fact, I missed the lease. Let it come day after tomorrow for final disposal.
There is nothing, I'll dismiss it.
Well, next week, any day next week.
The day after tomorrow.
Why next week I'm going, it will be in your favor you want. I may change your mind next week. I may set aside it. See, this is the against the discharge. You have been discharged in 2005. And they have filed this revision. It is pending unnecessary. We'll dismiss it, finish it up. Why are to suffer? Why they'll suffer at this?
Let me go through the file. No, I missed that list.
Tomorrow. Sir, these kind of matters I'll not talk fully.
It's all right. Tomorrow.
Tomorrow. You get ready. Prima facie, I am thinking that I should dismiss. Take the advantage. Whole matter 2005 discharged by By now, all the witnesses might have died. Yes, 36.
36.
1617.
Yes, 36. 48 years old.
1617.
He was 48 years old at the time of 2009. Will you see? This is 40, 30.
36.
Sudhir Kumar Jain.
61 years.
He was 34 in the year 1993. 1993, he was 34.
65.
They were 65. Non-APS for the petitioner. Last time it was taken up on the petitioner. This matter is listed for hearing. Hearing. In the interest of justice, the matter is urgent to next week date here. It is made clear that in the event non-APS for the petitioner, the court will proceed with the matter by appointing a magistrate.
Copy of the paperwork notes.
Copy of the paperwork is ready. Copy the IC is directed to supply copy of paperwork to Mr. Regime. Yes.
47.
May I please?
Yes, sir.
In first sub item, my lord, I am for Gannath Das. I have taken instruction, my lord. But I have not received the same, my lord. Let it come next week, my lord, for
Gauri,
complete instruction.
Gaur Chandra.
No,
Pariksha.
Gananath Das, I am for.
Huh?
Gananath Das.
Gananath Das, first
Yes,
item.
madam. Yes,
First item.
first item for.
Okay. You are appealing for Goro. It is written that he was 72 in the year 2009.
Nine. 2 years back, he has contacted me. Now there was no communication between the
And
appellant.
what is his age exactly? Have you
Exact now
seen it?
80 plus, my lord.
80 plus.
My lord. By Friday, I will get complete instruction, my lord.
Friday?
Yes, my lord.
Let it come on Friday.
Friday
You
or
also get
next week, my lord?
Monday.
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 Weekly
Okay.
test.
Both the matter
Both the
Monday. Yeah? You also get instruction.
Instruction.
My lord, paper book.
He is alive. First
My
item he may not be.
May not be.
Because 72.
My lord, paper book may be supplied. It's ready.
Paper book base is there.
पेपर बुक है ही नहीं तो मतलब दिया है
System.
पेपर बुक भी सप्लाई में I have not received the
Yes.
paper book.
38.
Monday, huh? Yes. It's 38.
38 9.
In 2000, he was 67 year old. Count.
67 plus 20.
91 now.
91.
Which area is this? Puri. Inspector of Police Vigilance, Puri. Puri means Bhubaneswar.
Bhubaneswar. Bhubaneswar division.
Bhubaneswar division. In the year 2000, when the trial was, when the appellant was facing the trial, he was 67 years old. The appeal is pending since
2009.
2009. The appeal Vigilance, Bhubaneswar, is directed to find out the whereabouts and well-being of the appellant and make a report to Mr. H.B. for the response. From 18.
Well, here also the paper book is ready. Maybe served on us, but
That day, if he
Well,
is alive, then
if
he
it's
supply
alive.
the court.
Well,
39.
$39.
39.
75 years in 2009. One appellant is was 51 years. What do? 39, na? Let us see 39, the TCR. They're very old. 51, one of them was 75 years and 51 years in the year 2009. Which area is this? Say motor coordinator. Which area? Huh? No. Cooperative. This is vigilance, na?
Yes, ma'am.
Vigilance. Kendrapada. Inspector Kendrapada.
Katak division. Katak division.
Madam, Katak division. Then Motor Katak division. Right. 18, huh?
Item 40.
Lord, item 40, my lord. I'm on VC, my lord.
Yes.
The file is misplaced, my lord. I was not able to trace the same. Your lordship may direct to provide me a paper book, my lord.
Whether your client is still alive.
I have also no. My lord,
He was 61 year old as per your memo in the year 2009.
My lord, as the file is misplaced, my lord, I was not able to contact me.
So what do you
I
want?
think it's a
In the weekly list get.
My lord, your lordship may call for a report even.
You come with a pen drive. You can take it from the registry. No
My lord, my lord.
Okay. Please it next week. Next week.
Also call for a report from the concerned police station so that it will be clear that he is alive or dead.
You seek instruction. You come tomorrow, get the copy. If you fail, then we will see.
My lord.
You please come with a with a pen drive and get the copies. Okay.
Oblige.
Okay.
41.
Somebody appeared that time. None appears for the appellant the time of call. However, release the matter. Sure. On the request of written counsel for the appellant, release terms. Okay. Weekly list. Huh? Yes.
42.
Yes, madam.
42.
Weekly? Ready? Weekly call.
My lord's copy of the paperwork can be served.
Paper book directly. Take. Yes, 43.
43.
39.
The same Kahani. $61 years. Non-appeals for the petitioner. Which area is this? Barampur division. Barampur division for the 18th. Okay. All the copies you give it to Mr. Vijay. Yes, next.
44.
Yes, sir. 44. He was 65-year-old in year 2009.
My lord,
1998, he was 65.
sorry, I'm item 41, my lord. Arjun.
You tell me whether in the year 1999 your client was 65 years old. Whether he is still alive or what?
Well, he's talking about item 41. Item 41 has been tagged in the weekly list. He's in 41, my lord.
Yes.
He's mentioning on 41. That has been tagged in the weekly list.
41 it's gone. I'm so sorry. In between, please don't come. I am getting confused. 41 is already. Yes, next.
44.
44. Yes, 44. Who is appearing? 44. The same story. That's what I was saying. 65, 1999. Vigilance वाला इधर देखो. Vigilance.
90. 90 years.
Which area is this? Hmm? Do you have file, Mr. Rizvi? You have file?
No, I don't have to file.
Take it up. Bhubaneswar, Vigilance SP Bhubaneswar. Take the files from the court file, no problem. Vigilance, Bhubaneswar division. Okay. Okay. 18. Yes.
35.
Ready? The client is alive. He gives which area is this? Hmm? Do you have any idea?
No, my lords, I'm not having the record with me. SP Vigilance, Bhubaneswar. my lords.
Bhubaneswar?
Bhubaneswar division, SP Bhubaneswar.
Bhubaneswar. That's 18. Yes.
48.
Item 48 is the brief has been transferred and kindly remove the power of the senior advocate Mr. D.P. Dhara and B.S. Dasparida.
Sorry?
I said brief has been transferred. Kindly remove the power of senior advocate Mr. D.P. Dhara and B.S.
Senior advocates have no power. They are
Mentioned
all
as
powerless.
cause list.
They are all powerless. They don't have power.
Because
Once you are designated, you become powerless. So you are appearing now.
On behalf of J.K. Panda, Jugal Yusuf Panda.
J.K. Panda is appearing. You forget. You forget. Same prayer, 1 week. You have make it 2 weeks. Sometimes make little changes. Same prayer, 1 week. Let it be there on the board. We'll see. Okay. You are 44 year in the year 2009. Let it be there. Oh, okay. Next.
49.
49 can you take the instruction to accept? Instruction regarding what?
Whether these
He was
the
50
appellant.
year
Yes.
old in the year
The
2007.
concerned learned court below advocates will take instance already inform him.
That comes for the petition appellant takes 1 week time to get instruction from his client.
2 weeks time, Bolangir case of Bolangir.
Or 2 weeks time, 2 weeks. Okay. Yes. 2 weeks. Weekly weeks. Let it be there in the weekly list. You get the instruction, we will take it up. Thank you.
Item 50.
Item 50 kindly be taken over next week.
Why?
This is senior will come argue the matter.
Have you checked up whether your clients are still alive or not?
No, no.
Have you checked up? Let it be there in the weekly list. Check it up and come. Don't ask for adjournment like this. Yes. Now, another. Let us understand exactly what is happening. Who is in 51? I'll take it 51.
51.
51. Let it be there. 51.
We'll see.
52.
Yes, sir,
My lord,
50.
the appellant is dead. I want to substitute illegal. In the vigilance case, fine is there, fine amount.
Yeah, 52. I'll await it and you move application. It stands awaited. Okay. Learned counsel for the
Your-
appellant submits that the sole appellant in this case has expired. In view of the same, the appeal stands awaited.
Your
Move an
lordship,
application for setting aside aside.
your lordship, item number 52, third item, sir. Third item.
52.
Yes, your lordship.
First item, this is criminal appeal number 525, 2009. Jhadeswar Patnaik, huh?
525 of 2000 is abated, my lords.
Abated.
And, your lordship,
He will move application whenever. Okay. And
third
You
item,
also may reflect in the order sheet that it will be unless EPT listed.
no, that's
It's not
that's
required.
the law. It stands awaited the day he dies.
It's a statutory right, my lords.
You can move application 394 application anytime.
Provision.
your lordship, third item, criminal
And
appeal number 51.
M. Prasad Rao 498 of 2009 also
Abated.
mentioned abated.
Abated. Only the last sub item is left. That is 519 of
519.
2009.
Yes. What do you want?
Your lordship, kindly allow after 2 weeks, your lordship. My senior is in accommodation actually.
Okay.
We'll
Let
take
it be
each-
there in the weekly list. We will hear 209, huh? Let it be there in the weekly list. Yes, next.
A paper book
If
may
that
be
two
supplied, your
matters are
lordship.
over, paper book ready?
My lords, here paper book needs to be prepared.
What paper book? You take it
Yes.
from pen, in the
Soft
pen
copy,
drive, you
yes.
take it and get
Soft
it.
copy. Yeah.
Yes.
Oh, bless.
Madam, item 50, my lord, sub item. The sole appellant is died.
50.
50. Mrutyunjay Maji, 469 CRL.
469 of 2009.
My lord.
The counsel for the appellant. 469, huh?
My lord.
2009. Then the counsel for the appellant
Yes, sir.
submits that the sole appellant in the
My-
present case has expired. You have a date?
No, my lord, I have not
uh,
dead.
Expired. In view of the same, the appeal stands abated, right? Yes. Huh? The other two matters will remain whatever. Date will remain. Yes. No, I will, let us see. I'll take it mentioning, the rest will continue mentioning. Yes, yes, sir.
No, there was a matter, 21, appellant has died on 15/21. I have given the case, sir.
Take it. 20,
21.
21, right on. 21. 21.
Yes, certificate.
What was the order in 21? Anyway,
No, it was just passed.
It was just passed over. my
passed
lords.
over.
Yes.
Okay.
21 with Lordship.
21. There. Memo.
Second, this is the death certificate.
Mr. P.K. Nando, let counsel for
Yeah.
the appellant,
Olga.
sole appellant,
Sorry.
has filed a memo inter alia stating that the memo inter alia stating that the sole appellant has expired on 15/5/2021. In support of the memo, he has also filed the death certificate, which is taken on record. The appeal stands awaited. Thank you.
I may be pardoned, Milords. Item 51, Milords, it was not updated in the display board, so I couldn't know, Milords.
50?
51, Milords.
Yes, what do you want?
Milords, we have sent letters to the appellant, Milords. This is again a trap
That
case.
will remain in the list. You tell
Yes.
me whenever it comes, no problem.
Milords, the same thing I will request that if my learned senior can take instruction of SP Berhampur Vigilance with regards
51,
to
ah?
51, Milords. We have
50.
sent handwritten letters, but no instruction
What-
has.
What is his age now?
Milords,
Okay,
if
which vigilance division?
Berhampur, Milords.
Sambalpur. Vigilance.
Sambalpur, Milords, sorry, Sambalpur.
51 record, huh? Sambalpur division. 18. Okay. 18. Yes, Mr. Paul.
Malab 58 is there. Let it. I'll do it tomorrow. My lord, I have some difficult today. It will be small matter, vigilance case.
Small matter, you don't come.
Small, because my lord, the teacher who was the headmaster who has been my lord entangled in this case is my lord the teacher of my friend in my SCB Medical College. That for that I had to come, my lord.
Okay, tomorrow.
Tomorrow, man.
Continue. Tomorrow.
Continue.
58 tomorrow, huh? Let it be there.
Yes, yes.
Tomorrow. Yes, I'll not take it. Any mentioning?
My lord, pardon, my lord. Item 62. I have missed the
62.
Yes, my lord.
If you have not reached 62.
It's
Bail.
oh.
Tomorrow.
No, it is already some order is passed. I have already signed. Might be. No adverse order. It will be taken.
My lord, Coagulant persons has gone from April.
It's all right. One week. 1 week. Put it next week. Monday, Tuesday. Take it. You should have come in bail matter. You should be at the top. It is written.
Yes, my sorry, my lord.
You should have been more vigilant.
Yes.
Anyway, next week. Yes. Any? Okay.
ଆପଣ କରିକି ନେଇଯାଇଛନ୍ତି।
There is a communication gap. One modification was not moved and modification was not granted. In the meantime, the copy has not been. I may today I have.
No, your lordship, 6/4/2000. I object.
No, but have you heard Mr. Naik? And I have directed last occasion. I have directed the IO of the case to appear. He is also appearing. Allegation is it seems your client is
that copy. Just now I received the copy.
No, your lordship, if copy has not been served, what the learned senior advocate was doing on 6/4/2023. Please wait. On 6/4/2023, your lordships, the learned senior advocate appeared and he was arguing the matter, your lordships. If copy has not been served, the file notice would have said that copy not served.
Anyway, Mr. Naik, see, the problem is bail has already been granted. It has to be cancelled. He need to have adequate opportunity to argue.
I'll file a counter.
And I'm dispensing. But you hear the IO.
I will work.
In the case diary, it is made an entry that your client is not only threatening the IO, and threatening the witnesses.
I know how to.
Very unfortunate. If at all, I will take instruction and file it without so-calls to the.
But that is entering the case diary.
Yes.
No IO will take that risk of entering in the case diary that you are threatening. If that is the case,
if that is so, Milord,
then the bail has to be recalled.
Let's Milord,
The
so-calls. I will also hear the matter after filing my.
I'm putting in the next week.
Next week, Milord, 2 weeks because I have to take instruction.
No, your lordship. No, your lordship.
See, you are with the impunity. You are violating the bail condition. And no indulgence should be given to you.
As you lordship fixes a date, I will come with your
next Tuesday, I'm fixing it and making it clear that no adjournment shall be given.
Yes.
Under any pretext.
Yes.
And your lordship.
Yes.
And
your lordship may indicate my name may be appear because that was Lalithendu
Mishra's name should be reflected in the list.
And your lordship may kindly indicate that the matter will be disposed of on that day. And if anything is
how you to detect direct.
No,
Can
no,
you
no,
wait, Mr. Rek? You wait. You are sitting counsel. You wait. Please. Without Milord.
It's all right. No problem.
Your lordship, a copy should be served to me beforehand so that he may serve me the copy on Tuesday morning.
If possible, I will serve. I'll take instruction. I'll prepare a so-cause and I'll file it. I'll file it.
I'll put it on Tuesday.
Your lordship may hear
it. Because the allegations are serious. Otherwise, generally, if the bail is granted, I never.
Milord, this aspect was raised before Milord the Justice Sangam Sahu, Honorable Sahu, and my lord was granted modification. The condition was and thereafter, I will come up with all so-called. I will satisfy lordship. Mr. Naik, have a patience. I will come up. Yes.
Tuesday 2 p.m.
Hearing also nobody appeared.
No, because there.
Whereas the reason that
yes, the name was not.
Name was not.
My lord.
And one more thing.
I will also file a Boklatnama because
Whenever there is a senior counsel appearing, I already told you.
yes.
Whenever there is a senior counsel appearing, ask the instructor.
No, my lord, this is not the.
Write his appearance also.
No, this is not passed by my lord court. That was passed other court.
No, the problem is
Yes, yes.
the way we are maintaining our proceedings is, in
Yes.
fact, there is a problem here. If a senior counsel is appearing and the instructing
Yes.
counsel name has to be there.
Yes, if name of that is a gap.
Because senior
that's
counsel
what's-
today, senior counsel would be there, tomorrow he may not be there.
Exactly, my lord.
The on record, whoever is on record, his name should be reflected.
Very grateful, my lord. That is the
Your
system to
Lordship,
be adopted.
Your Lordship, the IU present, your
And I will
IU,
file the Boklatnama. Yes.
your Lordship,
I'll-
your Lordship, the
So today,
IU,
what will happen in this matter? Mr. Manoj Mishra has appeared
Yes.
as a senior counsel. Your name is not there.
Yes, that-
Your Wakalatnama is not there.
Yes, that has not filed. Yes.
And if you go and ask Mr. Manoj Mishra, he'll say that I don't know, I don't remember who briefed me.
Very correct, my lord. Right.
How will you catch hold of?
your Lordship,
So on record, whoever is
My
there,
lord.
his name should be there.
Kindly direct my name may be reflected in the
Yes,
cause
yes,
list
yes.
and I will come up with. Grateful,
Please
my
do.
lord.
Yes,
Your Lordship,
yes,
your
Mr.
Lordship,
Pradhan,
your Lordship, he,
you need not appear
Sir.
next time.
Sir.
Mr. Naik is there to take care of your.
your Lordship,
Sir. Thank you.
let Mr. Pradhan, as Mr. Pradhan here today, let your Lordship take cognizance of what is actually happening. Your Lordship may hear it for 2 minutes. Next day I'll do that because he himself was present
All
there.
right, if he wants to come, nobody can stop. There is no direction, let
Yes.
him come. No
Oh,
problem.
please, my lord. Grateful.
Yes,
Your Lordship, 2 p.m. Tuesday.
yes.
Item 6.
What, this was what? 66. 66, okay. Yes, item 6. Yes, Mr. Rijvi, what is this?
It's a
Why-
appeal against conviction. It's a trap case, my lords.
Trap case.
Yes.
The last, see, nobody appeared earlier. In the last, on the last date, on 26/6/2024, I passed this order. If nobody appears, then, yes, you
My
asked it
case. Yes, ma'am.
as my case. No, because, yes. On, when the matter was taken up on 26/6/2024, the following order was passed. Okay. Even today, none appears for the appellant. Therefore, so-and-so is appointed as MA Keshwari. But paperbook was received directed to supply the paperbook. It is 2003 matter.
Yes,
So
ma'am.
get ready, please.
Yes, yes.
Help the court. Okay.
It's got in the weekly list.
Weekly list. Whenever you get ready, you please tell us so that.
I will give supply to you.
Yes, paperbook is, so I have given it.
Please.
28.
Minute, this matter will be taken up for next week.
Next week.
Yes.
What is this matter is about?
Appeal conviction in the vigilance case.
Okay, let it be there in the weekly list, we'll see. Okay, weekly, yes.
$78.
No password matter. Password matter. Huh? One matter was there, she was appearing.
80.
Matter transfer in 78 आवाने में भी deleted
70?
78 रे हमारा नहीं Mr. Jugal Kishore Panda is the counsel in
78, huh?
आज्ञा Mr. Ragadan associate name kind of deleted
What to do? Mr. Das, 78, na? 78, Mr. Das was there. It is states.
78 has, this is a vigilance revision matters.
Yes, that's what.
So Das will be appearing.
Some other. 76 now.
76.
Let it be. Which item you are? Mr. Ragada, you were appearing early.
But 76 matter, in that case, has already been urgent matter. Mr. Jugal Panda already taken the brief matter.
The one in 2013 matter.
80.
80. Let us see 80.
Mine.
78, 79? Adjourn. Good. Password. Over minute. Wait. 78 is again password.
78 is passed. 78, 81 and 84.
79?
Yes, sir.
Yes, Mr. Doctor.
Yes, sir, conviction yet. And last they have taken time to take instruction of getting payment of the amount. I have contacted the local council, but he has not informed me. That means the person
138.
Yes, madam.
What do you suggest?
Give me some time, madam. 10 days or so.
Check amount?
35. We are 35,000.
You are the petitioner.
I'm the petitioner.
I'll dismiss it.
On the next week, lots of next. One thing.
Next week. Monday. No, Tuesday. No, I'll not hear it. This week. Friday.
Friday, yes.
35,000 dismiss.
Yes.
And what I'll do is I'll tell you one thing. The best thing. It is I'll dismiss it for default. And if he pays, then I'll restore it. Best way of doing that.
The lower court, the warrant will be issued against that particular person. Again, he will come.
Then we'll restore it. That's the way.
Yes.
Only way. If he's not responding, shall I do that?
No, keep it next week.
Friday.
Yes.
Friday.
Next Friday.
Yes. Yes.
May I please, Your Lordship? My lord, here in this case, the present petitioner initially faced trial for the offence 294, 426, 324, 448 and 506 of the IPC and convicted by the SDJM Kuchinda for the offence 324 for 6 months and for 426 for 1 month and 447 1 month.
So 6 months is substantial.
Minor.
Next.
Then thereafter they filed one appeal. In the appeal, the confirm 426 acquitted and confirm for the 324 and 447 made on. And mine.
So the sentence 6 months remain.
6 months and 1.
Yes.
Right. And my
What are the injuries?
My daughter, here in this case, the IO and the doctor, they were not examined.
IO is not examined, doctor is not examined. Then how the trial court deals with it? Then it's a case of acquittal.
This is the PW1 and PW7, daughter of the NGO.
But what will be the consequence if the IO is not examined?
No,
what do you say? IO is not examined, doctor.
IO and doctor not examined. And in fact, the
Seizure
weapon or seizure PW 5 and 6, they have not supported the prosecution.
So, रह क्या जाता है? It's a case of acquittal then. Clear case of acquittal. How will you sustain the conviction?
The trial court has, the appellate court has.
Then you record anyone as injured and.
Evidence of the PW1 and 6, 1 and 7. Daughter of the NGO.
No independent witness supported the prosecution story.
That's what the senior witness is not.
Right.
That the sword, assisted by means of sword, it was not supported by the
The doctor.
The vital part is that my lord doctor and IO were not examined. And my lord the.
How do you know that the same victim appeared in the court? Or you brought someone else in to say that introduce himself as a victim and IO has to identify, or the doctor has to say, yes, I have examined him. Acquittal. Okay. Acquittal.
Oh, please.
My lord, that past counsel Narsim told that though there is a removed defect was not removed, he has to be
Gratitude.
Compassion.
And it is his duty, my lord. To bar, he has to give some amount.
No, cost, na? Then 5,000 cost, impose. 2,500 by literal and by you.
No, my lord, no. If,
Executed, huh?
yeah.
Simply the IO and doctor not examined. Executed.
Right.
Yes.
And Caesar witness not supported.
Caesar witness not supported.
5.6.
And 3 ground that has. Otherwise, why should you give PO? Unless it is a case of yes.
Okay. Yes,
Also, Mr. Das, Mr. Das is not here. Next, you call next, you forget about it. No, now we call whatever. $54. Revision.
Vigilance. So vigilance.
For lordship, let it lie over, my lords. Mr. Das will be appearing.
Today, Mr. Das is not
So
there.
he is on his legs in court number 2, old building.
Of course. Yes.
55.
You have 55.
It is ready for hearing. Actually.
This is conviction.
Yes, sir. We tagged in the weekly list.
So weekly.
56.
6, my lord, I have received the paperwork, my lord. I am ready.
Approved.
Yes, my lord.
Ready.
For you, my lord.
Ready.
Yes, my lord. On last occasion, your lordship directed to file the written note of submission.
Oh, matter is ready for hearing. Allow for it. You are ready?
Yes.
Oh. Yes.
In this case, my lord, the appellant convicted under section 13(2), reduced 13B and section 409 of IPC, my lord, for a period of 1 year, my lord.
1 year.
1 year, my lord. While he was, the prosecution allegation is that, my lord, while he was working as a forest range officer, my lord, there was an allegation that 1,33,000 of rupees is shortfall, my lord, which he answered during his 313 petition, my lord. And also he has established during by DW1, my lord, given his defense evidence, my lord, how he has disbursed it, my lord. Your lordship, come to page 18, my lord.
This is item 54, no?
My lord, 56, my lord.
56.
Huh?
Okay, LCR is there.
Which 18 is to 9.
18 page, paper book. 18.
Where are people then? Yes.
Page 80 proceeding. Though charge sheet was submitted in June 1998, neither the prosecution nor the defense put able to say the result of audit nor the report was brought out. So from it can be inferred that after joint verification, the accused handed over the government money, maintained the PL account register, and January 1997 DFO Kendulu endorsed in Exhibit 1 that rupees 73,800 was correctly found with the accused. This goes to indicate that some adjustment by the accused was made towards the shortfall of amount against which prosecution has not established that no subsequent adjustment has taken place. So far as the submission by the accused, the fact remains that till joint verification report, without any voucher on receipt that there was shortfall of rupees 1,36,000 paisa, and the same was subsequently adjusted after maintaining the PL register by him in January 1997. The IO also did not make any other inquiry by examining other private or official witness to ascertain the truthfulness of the claim by the accused or the negative his claim that the shortfall amount were utilized other official purpose. Nothing has been brought out by the accused if the case of rupees 1,38,000 which is inside the iron chest accused if the case was properly reflected in the connected casebook. So keeping in view of the stand taken by the accused, there appeared that manifest of default in maintenance of account handled by the accused received from DFO and has failed to establish that government money so entrusted was for official use. At the same time, it cannot be ruled out that the shortfall amount was adjusted after 7 months of joint verification. And your lordship see the defense witness, my lord, DW1, what he has stated.
60 minutes.
60.
Yes, ma'am.
Yes, my lord.
Yes.
On 27/6/1996, I was the, sorry, my lord, defense witness. April, after collection of money from DFO, the range officer used to give advance to us in phase manner, and we used to submit the final account during the August. At the time, we have received the advance from the range officer. Though the forest guard being sent by us at the time, we had no occasion to meet the range officer for month of together for field work. We used to submit the detailed voucher to the range officer in August. The forester do not maintain any case book, and the case advance to them are maintained by the range officer. On verification of PL account maintained at the range officer, I had received the advance of 3,54,000 from April 96 to end June 96 as per the PL account exhibit produced today in 2 volumes.
What do you say?
This shows, my lord, the present accused has given the cash to the forester and other official to collect the kendu leaf, my lord. In lie up to that, my lord, he has given the money, my lord. Advance money. And only defect is that, my lord, he has not received the vouchers from the beneficiary, my lord. And the IO has also examined during his cross-examination, my lord, during investigation, my lord, he has not examined any of them, my lord, who has given the money to them. And in the midst of the...
What is the procedure?
The procedure is, my lord, the process start, my lord, January 2.
January.
And the end is up to August, my lord. In the midst, my lord, the investigation was carried on, my lord.
No, what is the procedure? How the money are collected?
Money was collecting, my lord. The range officer used to give the money to the forest guard and other official, and he collect the kendu leaf from there, my lord. That is the procedure.
1,38,000 rupees was found in the
shortage.
But in the midst of the season, my lord, investigation was taken up, my lord.
Okay.
In the June.
But out of that, he has already only adjusted how much?
78,000, my lord.
And what about the other money?
Other money, my lord, that is my whole point, my lord. That the whole point is that, my lord, before ending the session, my lord, investigation was carried on, my lord.
You want to say that since the session starts in January and
August,
the reconciliation of the account should have been done at the end of the season.
End of the season.
So in between you can't come and start asking for inventory and account, which obviously will have a difference. Because the reconciliation could be done at the end of the season. Because this is a running process. Advance is paid and voucher is collected and all. In between these case was registered and paid whatever has taken.
And
that's your whole.
Yes, my lord. And to that effect, my lord, the investigating officer had not examined any of them, my lord, who has given the money, who has received the money. The IO has also admitted in his cross-examination.
Where is that?
He has not examined any of independent witness also, my lord. Schedule 4 is the IO.
It's 49.
49.
Yeah.
52, cross-examination part, my lord. I was a member of first reading party dated such and such when the
relevant party.
Reading party.
Relevant part.
Relevant party is 52. Paragraph 7, my lord. I was a member of first reading party dated such and such when the charge in case of some is not visible, my lord, clearly. Accused explained that Yes, my lord. That is not clearly visible. No, that-
Office staff and
Page 52 is not clearly visible. Unable to read also.
where does he say that I have not collected the vouchers and all?
Paragraph 8. Till my investigation, there was not visible, my lord, clearly. Lordship, one more opportunity may be given to take out a print copy, my lord.
Come to page 53, para 9. You have given it the money to the forest guards and all.
My lord.
Okay, he says the forest guard and the forester who had received the advance from the accused were not examined during the investigation.
Yes, ma'am.
And I have not seized any receipt relating to the receipt of case by the accused from DFO office.
That is the lacuna of the
Since
prosecution.
most of the advances from DFO office were in the form of check. Exhibit so and so, so and so, form so and so, and the forest guard and forest received
No
money.
endorsement. Yes.
But there was no endorsement
Yes, ma'am.
by the disbursing officer. But those receipts were seized from the range officer. The receipt of so and so, so and so. Yes.
That apart, your lordship may kindly come to the 313
But
state.
these are the procedural error.
Yes. Because entrustment was very much there with it.
Entrustment is there, in between you go, they can't be reconciled and you don't collect everything. And these are the procedural error. Endorsement nahi hai, this nahi hai.
Lordship may kindly see.
Where is the mens area?
313 statement.
Mens area not
in
been established.
313 statement. Page 40.
40.
Yes. What plea he has taken, my lords? It is just denial simpliciter, page 42, question 15.
401.
42, my lords.
42.
Yes, question number 15.
Yes.
You have heard the evidence against you. What more you want to say? It is just denial simpliciter.
You have to prove your case whether
yes,
he
my
has
lord, that I am
denied.
coming. That I am coming to that. Then your
What
lordship
is your case?
Exhibit 8, which has been maintained by the accused himself. He accepts that he has received a sum of rupees 21,80,000 sum. So entrustment part is very much there. Next thing remains means how far he has discharged his duties as far as this amount is concerned.
You are not investigating regarding his ability to discharge the duty. You are investigating his criminal misappropriation.
Yes.
You have entrusted the money.
Yes.
He has utilized that money by giving advances to the forest guard and forester for the purpose of procuring the kenduli. And in between, when you read it, you find there is a shortfall of 1,38,000 rupees. And in the evidence, it has come that subsequently it was adjusted. 78,000 also adjusted.
Temporary misappropriation. Admitted.
Adjusted. So what his case is, from January to August, this kendulip season goes on. And in between, the reconciliation can be done at the end only. Or in between, if he is transferred, the officer who will take over, while giving charge, reconciliation is made. In between, you go and raid him and say that 70,000 is not.
There is no bar.
I'm not on the bar. I'm not saying that you are not entitled. But how will you bring mens area to that?
The way he has disbursed the money without having any receipts to that, my lords.
That is dereliction of duty.
My lords, may kindly come to the findings, my lords.
What is the departmental proceeding
Department not
against you?
initiated. No departmental proceeding initiated.
What about sanction?
Sanction was taken. The PW5 is the sanctioning authority.
Tahsildar is the sanctioning authority, my lords.
No, sanctioning authority PW5, no?
Yes.
PW7, ma'am.
7.
PW7 is the
Principal
sanctioning
chief.
authority.
Page
58.
Page 58.
58. Yes. Yes.
And
Yes.
for dereliction of duty, my lord, there has to be a departmental proceeding, my lord. The IO can't say that, my lord, there is a dereliction of duty. It is the duty of his authority, my lord. They can only say that. Out of 7 witnesses, my lords, 4 witnesses belong to a vigilance official, my lord. Only 1 witness that belongs to the cashier of the Cancellation office, forest office. No independent corroboration is there, my lord. Though he has stated in the defense witness, my lord.
Yes. And once the onus is established that he was
Onus
entrusted
is
with
to-
that money, matters, then then he has to satisfy how he has to discharge his duties. His
Yes, he has
intent
a-
was very much there when there was misappropriation, even if temporary misappropriation. Your Lordship may kindly come to the observation made in the judgment, my lords, page 18.
Page 18.
Yes, my lords, where he has failed in his duties. Para 11. As per the joint verification report, Exhibit 1, the PL registers Exhibit A to A2 were not maintained by the accused since his joining from April 1996 till joint verification was done. Accused has not produced any other connected receipts, vouchers, registers showing that money was actually advanced. Though PL accounts register accused has failed to show that before the joint verification, different amounts to the extent of shortfall were given in advance. It did not indicate their names. No other receipts or in form number 51, any vouchers were produced through which such shortfall was reconciled in January 1997. But this is all the preparation of his evil intent of misappropriating the entire money. And the onus is now on him to discharge.
The IO has not made any attempt.
No, my lord. I have not examined any of the evidence, my lord, witnesses. For that reason, my lord, the appellant has established by DW1, my lord. DW1 categorically stated, my lord. He was the ex-forester, my lord. What is the procedure? In page 60. He has
No,
detailed discussed about.
Question is, if the vouchers were not prepared by you,
Yes.
where from the IO will get
Seize,
it?
my lords.
My lord,
When
in
there
the
is
midst, my lord. In
That's the
that-
finding it.
No, my lord. But the procedure.
Para 11 says, neither you have prepared voucher, nor
PL register.
any advance to whom you have given. You
Receipts.
have not maintained register,
No
nothing is
receipts,
there.
nothing.
Only, my lord, only is that, my lord, he has not collected the voucher, my lord. So that explain, my lord. No explanation has been given either to.
No, he says that you have not maintained the
Register.
Record, he has
since
maintained
you
the
joined
PL.
in 1996.
That is the previous one. That allegation is not there. Allegation is that from January 96 to August 96.
And this
my
is
lord.
not
That is-
maintaining.
It says
in the previous year, there was no allegation, my lord. Allegation is the.
Allegations might not be there, my lord, but he was not maintaining. My lord, these are all the intent of him to
For
misappropriate
that reason, there was a separate proceeding.
These are the
They has to
preparation for
initiate the departmental
misappropriation.
proceeding, my lord. There is a separate proceeding to initiate departmental proceeding.
That is
the
different.
due recreation of
Mens
duty.
rea,
But
this
here
is
is
the
not.
preparation for misappropriation.
No, mens rea not yet established. The prosecution
Yes.
fails to
No, one
establish
after-
the mens rea.
Let us see one after another.
There is a
See,
set of
except your
procedures.
DW who says that advance was given to him.
My lord, my lord.
What else you have?
There is a set of procedures that are actually
Yes,
followed by a government
but
servant.
IO
Not at
failed
his
to
own
establish
whims
that,
and
my lord.
fancies.
IO admitted that during investigation he has not examined any of them.
No, IO, that part you want
Yes,
to
the IO is
deny,
the
but
best person, my lord. The IO is the best person to answer that. and no explanation has been given if any shortfall amount is there, then he could repay the amount also. That opportunity
In that
has
case,
also
how
not
is
been
he going to
afforded.
discharge the owners, my lords?
That opportunity has also not been afforded.
What is the extent of misappropriation?
Minus 1,36,000.
1,36,000.
No, but after the verification,
Reconciliation.
it is adjusted. How much you adjusted?
73,800.
That 73,800
Yes, minus
was
part
correctly found.
Yes,
in
ma'am.
the accused.
Part misappropriation is good enough for him to be convicted.
So what is the extent of misappropriation?
Minus that amount.
Minus the what amount? Do it. 1,38,800 78,800.
Minus
73,800.
662,213 is the balance amount.
To that effect, my lord, no show-cause was also afforded to the
Yes.
appellant, my lord. If any show-cause was given.
Is there any procedure for that?
No, my lord.
And my
But
lord-
in the midst of the season, my lord, the investigation was carried.
And my lords, with due respect, if this investigation and joint verification would not have been done, he would have
Yes.
parted with all the
No,
money
investigation should have been
without any remedy, my lords.
investigation should have been taken after the completion of the session, my lord.
What are the materials you have to show that the session starts at January?
Yes, my lord. DW1, I have examined DW1, produced the DW1. DW1 stated that, my lord, the procedure. He was the ex-forest officer.
50.
Page 60, my lord. He has stated.
My lords, the accused here is the range officer. He is not the forest officer.
No. The DW1,
Yes.
defense witness.
Yes, he happens to be the forester, no?
Was he,
forester,
was he
forester.
working under him?
No.
Yes, ma'am. Previously.
This
ma'am.
DW1 was working under him.
When? Which period you are talking about?
No, ex-forest officer.
He is an ex-forester. my lords.
Ex-forest officer.
He is a retired one.
Who will come in defense evidence? Retired will come.
Yes, ma'am. Accused Kanucharan Tudu was the range officer Kendulip, Navarampur. There were 4 forest section under the Navarampur range officer like Tentulikanti, Majhiguda, Bikrampur, such and such. Kendulip session start from 10th February and the process end in August of each year. And the investigation was carried on June, my lord. After end of session, my lord, he can give the answer.
FIR case is registered on
Case registered on June, my lord.
date.
27/6/1996. In the midst of the sessions.
No, my lords, I am also
How can
relying
he
on
give the explanation?
I am also relying on the same evidence, my lords. If your lordship may kindly come to page 60.
60.
60 it starts from.
Yes.
61 here.
I am on 61 only.
Yes,
I'm
ma'am.
reading
No,
that.
Yes, first line. The forester do not
Cross examination. Para 2.
just above that in chief. The forester do not maintain any cash book, and the cash advances to them are maintained by the range officer. Here the accused happens to be the range officer. He has
He is
not
supposed to
maintained.
maintain
Yes,
it.
my lords. He has not maintained anything. On verification of the PL account maintained at the range office, I had received the advance of rupees so and so from April 96 till the end of June 1996 as per PL account. Exhibit A produced today in 2 volumes. But what I want to thrust is that he has deliberately failed in his duty to maintain these accounts, which was his duty, with the intent to misappropriate it. Had this joint verification not been conducted in the midst, this factum would have gone unabated. He would have misappropriated the entire thing. Nobody could have known about it. It would not have seen the light of the day.
Who is this DW2?
Another witness, my lord, defense witness.
And my lords, DW2, the second paragraph, your lordship may kindly see, the cross-examination part. This is also very important.
DW?
DW2, page 62.
Yes, I am reading there.
The second para.
Hmm.
As per
That's the
exhibit
exhibit
A by
A
2, audit was made on 24/11/98. The accused was range officer during May 1996. And as per exhibit A by 1, the PL account register he made endorsement for the end of May 96 was rupees 16,345.82. Cash in hand at page 117. Again, as per his endorsement by the end of June 1996, the cash balance with him was rupees 1,10,190 at page 145. And there he had endorsed that he will be held personally responsible for the safe custody of the same amount.
This is the DW2.
Yes,
DW2.
madam.
The examination chief just read as per the direction.
As per direction by this court and being entrusted by the range officer Nabarangpur, I am producing the PL cash register of Nabarangpur range volume so and so from dated 28/4/95 to 15/6/98, showing the advances of money made by the range officer and the expenditures incurred by them. Exhibit A by 1 and A by 2 are those registers. During 1998, the office of range officer was audited. Thereafter, my lords, at page 3, the para 3, I have no knowledge regarding the report by the audit. As per exhibit A by 1, the accused received a sum of rupees 21,80,385 from DFO, Kenduleaf, Nabarangpur from 6/4/96 to 25/6/96. As per exhibit A by 1, the cash balance as on 25/6/96 was rupees 4,68,826.82 paise. And on that date, he had received rupees 2 lakhs from DFO Kenduleaf, inclusive in the above amount. The range officer used to maintain these registers. Unless neither he has maintained the PL account, neither he has produced the receipts.
The figures are different everywhere.
Yes. Unless these figures are inclusive of the entire amount that he has received. The figures are never disputed, Your Lordship. Lordship may kindly see exhibit 8. This is maintained by the accused himself.
Exhibit 8.
Yes, madam. This is an exercise book which has been exclusively maintained by the accused, which reflects that accused has received rupees 21,80,295 in between 6/4/94 to 27/6/96.
Yeah, yes. Exhibit
8, madams. Receipt of the money is never disputed. He admits that.
Yes.
But in the present facts and circumstances, I'm relying on a judgment, my lord, so I kindly have the glance one. Only one paragraph, I will not take much time. Yes, I am relying on a judgment reported in AIR 1960, Supreme Court 889, Jackishan Das M. Desai and another versus State of Bombay. Lordship may kindly come to para 6, page 185.
Yes.
The 8th line from the bottom.
Para 6, huh?
Yes, ma'am. The 8th line from the bottom. The sentence beginning with the principal ingredient of Lordship got it?
Principal
Malice. I am just placing it. The principal ingredient of the offense being dishonest misappropriation or conversion, which may not ordinarily be a matter of direct proof. Entrustment of property and failure in breach of an obligation to account for the property entrusted, if proved, may in the light of other circumstances justifiably lead to an inference of dishonest misappropriation or conversion. Conviction of a person for the offense of criminal breach of trust may not, in all cases, be found merely on his failure to account for the property entrusted to him or over which he has dominion, even when a duty to account is imposed upon him, but where he is unable to account or renders an explanation for his failure to account, which is untrue, an inference of misappropriation with dishonest intent may readily be made. Right? In the present case, he has miserably failed to account for the misappropriated money. Entrustment has been proven. Onus was on him to prove and discharge his liability, which he has utterly failed. And there is part misappropriation.
Here, my lord, I would like to say that, my lord, that ratio is not applicable to this present case, my lord. Here, this mid of the sessions, my lord, the investigation was carried on. After end of the session, he can make any allegation.
Okay.
And there was no audit, my lord.
Apart from that,
my lord, no audit was found, my lord. Audit was not been conducted.
So how
And
the audit
hardly
is connected?
It is a case of hardly even.
How can an audit justify this, man? I don't understand this argument. I fail to understand.
Let us see how the trial court deals with.
The trial court has dealt in great detail matters. All aspects have been dealt with supporting case laws.
May I place the one case law, my lord? That is, I have given in my written note of argument also, my lord. At 1971 Supreme Court, my lord. It is not necessary for an accused to establish his plea beyond all reasonable doubt, as in this case of the prosecution. If an accused
Where are you reading?
I have given that judgment also in my written note of submission.
The written note is there, but judgment is not there.
Judgment.
Which paragraph?
Sorry, my lord, I am coming to this, my lord. Out there. Very clear. In page 24, my lord, here also reflected that judgment also dealt with, my lord. Page 24 of the paper book, my lord. Paper book in page 24.
Page
24 of the paper book. Criminal trial, defense case. It is not necessary for an accused to establish his plea beyond all reasonable doubt. As is the
where are you reading?
page 24 paragraph, last paragraph.
Yes, criminal trial.
Yes, ma'am. It is not necessary for an accused to establish his plea beyond all reasonable doubt, as the case of the prosecution. If an accused person give a reasonable and probable explanation, it is for the prosecution to prove affirmatively that the explanation is false. He has proved, my lord, through the DW1. And the prosecution failed to prove that, my lord, by way of the investigating officer.
And his
The
explanation is-
investigating officer fails to answer that, my lord.
No, no.
He has not examined any of the
you
witnesses,
are
my lord.
citing this judgment of 71.
My lord.
You tell me which paragraph you want to rely upon.
Certainly.
You can't expect me to read the entire judgment unless you show me the relevant part. And what is your proposition to support it?
Proposition, my lord, the
You want to say that the onus was them
Onus
on
of-
them to prove it
both of them, my lord.
beyond reasonable doubt.
Yes, my lord. Onus is
But
also
in the entrustment, if the entrustment is proved,
Proven,
then
yes.
the onus shifts to you.
Shifts to him. Yes,
Yes,
to
my lord.
prove that,
I'm obliged.
yes,
I have given my explanation, my lord, through DW1, but they failed to answer by the investigating officer. It is the duty of the investigating officer. He has to collect the independent witness.
Show me from this judgment which you are.
The PW.
No, judgment you show me, the judgment which you are citing. What is the law laid down?
Oh, in this judgment.
Yes.
Sorry.
What is the ratio descending?
Para 6. Para 6. 1960. 1960. 1960. 1960. AIR 1960. SC 89. Para 6.
Ravindra Kumar versus State of Orissa.
Citation.
1976 Supreme Court.
You tell me what are the
76 Supreme Court, page 170. 170. Yes, my lord. Page 8, my lord, paragraph 2. That in a criminal trial, the accused must.
8.
My lord. The judgment. Page 8, paragraph 2.
Yes. Page 8 para 2.
Para 2 and para 1. That onus
Yes.
lies affirmatively on the prosecution to prove its case beyond all reasonable doubt, and it cannot be derived any benefit from weak. And paragraph 2, my lord, that in a criminal trial, the accused must be presumed to be innocent unless he is proved to be guilty. And
That's
three,
general
principle.
that the onus of the prosecution never shifts.
General principle. My lords, may kindly come to the deposition of PW3, my lords. Page 47. Who happens to be the cashier cum in charge head clerk of the concerned division. Also kindly have a look.
Yes.
Page 47. Only 4-5 lines I will be relying upon.
Then you just answer me now. I got it, the entire issue. The issue now boils down to one thing. That when the onus is on an accused, then he has to, he need not prove beyond reasonable doubt. Preponderance of probability, preponderance of probability rests there.
Yes.
Finished. So far as the accused is concerned. But in the converse situation is, if the onus is in a prosecution, the prosecution has to prove beyond reasonable doubt. What he is trying to say is, I was supposed to give the account. Onus was on me to explain it. I could explain by saying two things. One is, in between, the reconciliation could have been done.
At the end of the year.
Reconciliation could have been done at the end of the season, which ends at August. And this has been done in June. So it could not reconcile. First issue. Second issue is to prove that I have given advances, which is not reflecting it. I have examined one witness, that is DW. So the preponderance of probability is there. I have discharged my honors.
DW1 only says the modus operandi. He doesn't say
He
that.
need not prove to beyond reasonable doubt.
Yes,
He has
preponderance of
created a dent
probabilities.
in your story.
Yeah, my lordship on the preponderance of probabilities.
Yes.
DW1, what does he say? Your lordship may kindly come once again to
here.
Page 60.
He only says to the extent that yes, I had taken the advance. Yes, that's all.
Yes.
I will not go to the figure. We are not on figure.
No, we are not on the figure.
There was an entrustment. Part of the entrustment amount is misappropriated.
Yes.
By not properly accounting
for. Yes.
This is the whole gamut of the. He says that accounting could not have been done because I had given advance and it is in between the season. So therefore reconciliation.
So my lords, I put a question to myself. He is a government servant, my lords. Is he not bound by the procedures to be laid down?
That
One
is
government
dereliction of duty.
one government servant cannot take out any amount of money and give to anyone without any acknowledgement according to his own whims and fancies.
For that reason, there is a separate procedure is there.
We are on 406.
Separate procedure, that is.
How to get out of this position? 406. Let us see.
The judgment which I am relying upon, it's very clear on that aspect, my lords.
That's there.
It's very much clear. It squarely covers the present situation.
Let us see the chapters.
My lords, may I just once again place it, my lords.
Yes. How the trial court deals with it.
Yes. Trial court has dealt at page 25 minutes. There are 16 onwards. 16 onwards.
1 minute. Here. 16, 16?
Yes, my lords. Para 16, page 25.
16.
My lords,
As seen.
Yes, as seen from evidence by PW3, my lords, this is the cashier. PW4 is the IO. On 27/6/96, the accused was working as range officer Nabarangpur as per his service book and PC file seized from PW3 with Exhibit 20. From the evidence by PW1 to 6, it is seen that on 27/6/96, a joint verification was made with respect to physical verification of cash position of the office of the accused by the DSP Vigilance, Inspector of Vigilance, in presence of DFO Kendulif, Tehsildar Nabarangpur, Senior Clerk and the accused range officer, during which, on production by the accused cash book and other vouchers, documents were verified and taking into account all the details produced by the accused, cash shortage of rupees 1,36,013.36 paisa was found. During joint verification, it was noticed that the accused had not maintained the PL account register to which he was supposed to do since the day of his joining. As per PL account register of DFO, Exhibit 17, the accused has received 21,80,295 in shape of checks and cash in between 6/4/94 to 25/6/96, which was also supported by the exercise book officially maintained by the accused. And this I was talking about Exhibit 8. Regarding the receipt of the above cash from DFO, Exhibit 8, as per Exhibit 1 and the evidence by PW 1 to 6, the accused produced different vouchers through which he had given advance of rupees 7,42,700 to Forest Guard Bikrampur section Vide Exhibit 12, some with dates of one date, many without dates, and none with voucher numbers. Your Lordship may kindly appreciate this. Rupees 2,61,050 to Forester, Majiguda section. Exhibit 13, none with date and voucher numbers. Rupees 3,82,400 to Forester Kendulif Nabarangpur. Exhibit 14, none with date and voucher numbers. Rupees 3,25,000 to Forester Tentuli Kunti. But there, the accused had not given any certificate regarding disbursement of advance in any of the vouchers.
All these things are dereliction of duty.
My lord, intent is also there, my lords.
Only misappropriation is 1,38,000.
My lords, may
And
kindly
the
appreciate
advance is paid, he is not obtained signature.
My lords, 1 lakh.
All these things are complete dereliction of duty.
My lords, 1,36,000 in the year of 1996 with the
No, to that extent you show me. All these things, subsequent things which you are reading, it has nothing to do with the case. He has paid this much without taking signature. He has paid this much without taking the voucher. And all these things are neither here nor there. Because entrustment is you have paid this much money. He has misappropriated it or used it for his own advantage. This is the whole case. Of,
once the entrustment is proven, onus is on him to
entrustment
discharge it.
Entrustment is proven because official capacity has received money.
Received the money.
Whether that money he is accounting it or not subsequently.
Yes.
Is the issue.
Yes, my lords.
So therefore, 1 lakh when
so even if my lords he has accounted for 76,000.
When the vigilance people have gone to the office, that day 1,30,000 was 30,000 was falling
deficient.
short.
Yes,
falling
deficient.
short.
Yes.
And yes, falling short, no problem.
Yes.
And whether this money was asked to him by where has it gone?
No, my lord. That explanation not given.
That must have
You bring it.
No.
It is not a immovable property that he sold it.
No.
It is a matter of cash. He might have kept it somewhere. Instead of keeping it in the resident, he might have done it. Or he might have given in interest.
Can he do that?
For example, interest.
And there is
What is your case?
And there is also no allegation.
You should have given an opportunity to him.
Yes.
This shortfall amount, you
He
have
has
to make
made
good
He has
immediately.
My lords, may kindly see the joint verification report.
There is
my lords.
also no
what
material-
explanation he has given.
78
What explanation he has given, my lords, in joint verification report.
Then how do we over?
Yeah, examine it. Yes.
Kindly see that, my lords. Exhibit 1.
Exhibit 1.
1. Joint verification report.
Yes. Is there in the paperwork?
Page 34, exhibit 1.
Yes. Paperwork.
33, no, exhibit 1.
30?
paperwork. Only that was
It's not
mentioned,
there in
joint
it is
verification.
not a part of the paper book. Your lordship may kindly see the LCR. It is exhibit 1.
No, you show me from the trial court judgment where it deals. Does it deal with that?
I was just about to read that, man.
Yes. You were reading there, yes, 25 you were reading.
Yes, my lords.
Hmm.
My lords, kindly come to page 26. Up to 25 I have completed.
Yes, yes.
26, the first line.
Hmm.
The sentence beginning with, but there the accused had not. Lordship
Yes.
have it, man?
Yes, yes.
But there the accused had not given any certificate regarding disbursement of advance in any of the vouchers. Again, he produced acquittance for rupees 26,044 towards payment of remuneration to seasonal staffs for February and March 1996. Exhibit 11, he produced 32 numbers of bill cash memos towards purchase of GI pipe, hand pump, etc., amounting to rupees so and so. Exhibit 10, he also produced 4 numbers of vouchers regarding purchase of Kendu leaf from Munsis in between 7,496 to 22,496, total amounting to rupees 33,789, which is exhibit 9. Again, from his iron chest, rupees 1,38,805 was physically verified in shape of cash. The closing balance as per A management cash book maintained for the government money was rupees 16. Again, accused produced 6 numbers of token out of PL account checks amounting to rupees 1,05,000 of dated 25/6/96, which were received in shape of checks from the DFO on 1/6/96 and 2/9/96. The joint verification was in the presence of accused. My lord, this is important. The joint verification was in the presence of accused, other officers and officials of Forest Department, Tahsildar, and informant, IOs, which has been corroborated by the evidence of PWs 1 to 6, who have categorically stated that during joint verification, rupees 1,36,013.36 paisa was found to be shortage, which was misutilized or misappropriated by the accused. During joint verification, the accused explained that he had advanced money to different persons, but vouchers were not obtained. Undisputedly, during joint verification, it was found that the accused had not maintained the PL accounts since his joining, which was he was to maintain daily basis. Now, under Rule 323 of the Odisha Forest Code, a fund application in Schedule 18, form number 79 will be made by the disbursing officer on the last day of each month to DFO for the advance required in connection with the work to be executed during the month. Further, under sub-rule 3 of Rule 324, for each such advance paid, the range officer shall obtain receipt from the payee and charge it in the cash book as usual, which he has not done. The receipt should be submitted to the DFO with his monthly account. He should also maintain a disburser's ledger in form number 44 and submit an abstract to the DFO in the same way as the latter does to the AG as per the sample entry shown therein. Again, it is stated that the A management cash book is meant for government transaction.
So again, all these things.
For this reason, my lord, he has to face the departmental proceeding.
It
is not for criminal liability.
Well, this is the rule which he has
come to the previous line.
This is the no criminal liability.
1 minute, Mr. Mishra, please. You have to render help. You are not rendering. Both of us are doing your job. You show me some judgment.
Yes, paragraph 12, my lord. Your lordship kindly have it.
Mr. Grisby, come to this line. Come to this line, earlier line. Undisputedly during joint verification, the accused explained that he had advanced money to different person, but the vouchers were not obtained.
Yes.
Okay. And to substantiate this, he has laid DW1, which is the preponderance of fraud.
DW1 states about, kindly, may I just take your lordship to DW1 once again?
And rest of the thing, he should have done this, he should have done that. That is auditor's business. It is not criminal jurisprudence required to go on into all these issues, you know. He should have maintained voucher. There are rule book, how to handle the cash.
Yes.
Because he was the range officer. He has not followed the rule book. All these things are there. So departmentally he can be prosecuted. Departmentally he can
My lordship kindly appreciate the intent, my lords. Why he has not maintained those things? Right from the very beginning when he joined, it is not about only that gap. Right from the beginning he is not maintaining, my lords. Intent is very clear. Had this joint verification not been conducted, this misappropriation would not have seen the light of the day.
On the basis of intention, can you prosecute 406?
My lord, 409, my lords.
409.
Dishonest intention, the case which
No.
I am citing, it squarely covers my situation, my lords.
No, he may have, just see 409.
Paragraph 12 here, Lordship. Kindly see.
409. One,
Judgment also.
1 minute. None maintaining the record and all. He
No,
has,
but I'm on
he may
top
be
of
having the
record, my
intention.
lords.
But whether the intention.
What, also, Lordship, may kindly see what does 409 says.
Yes, let us see.
May I just place it?
Hmm.
Lordship got it, my lords? 409.
Yes, and there.
Criminal breach of trust by public servant or by banker, merchant or agent.
Hmm.
Whoever, being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker, attorney or agent, commits criminal breach of trust in respect of that property shall be punished with imprisonment for life. And this is the penal section.
Hmm.
That malus can go to 405 malus.
Yes.
Criminal breach of trust.
Hmm.
Whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property or dishonestly.
That's not your case.
My lord, he has converted.
For that reason, charge has to be framed, my lord. No charge has been framed for that offense.
1 minute, yes. Misappropriate or convert to his own use. That property.
His own use that property or dishonestly uses or dispossesses of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged or of any legal contract, express or implied, which he has made touching the discharge of such trust or willfully suffers any other person so to commits criminal breach of trust. Well, this is important. Property in violation of any direction of law prescribing the mode in which such trust is to be discharged. He has failed in this discharging this duty, my lords.
Then in that context, you are correct.
Yes, my lords.
Because if there is a prescription.
Yes.
For that reason, no charge.
To deal with a particular property.
Yes, ma'am.
Don't deal with it also, you are liable.
Yes, ma'am.
Charge has
In a
to be framed,
particular
my lord.
manner.
For that reason, my lord, charge has to be framed under section 40 for that offense. No
that
charge.
that was the offense.
The offense is always there.
No, my lord. For that reason, no charge has been.
No, 405.
405, no charge has been.
Yes, 405.
He has been convicted under section 409.
409 is the penal section. That is the punishment. That is the penal section.
But what is the charge?
The definition is there. 40.
No, that is the definition. But charge has to be framed to that respect. Particular charge has to be faced. And most interesting thing is that, my lord, after the closure of the session, my lord, they can say anything, my lord. Before that, my lord, they can't say.
What is the amount?
Non-maintaining of record, hardly it is a case of departmental proceeding, my lord. No criminal offense is made.
405, yes, it is very clear. 405. Uses, yes.
Come to para 22. 31. Page 31, para 20. Read it.
Last parameters. Under the aforesaid circumstances, when it is seen that the act by the accused was willful negligence giving rise to criminal liability, or misconduct and breach of trust for temporarily retaining otherwise than official purpose and misappropriating the government money for certain months without reasonable and probable explanation.
What is this? Temporary entrustment?
No, he means
For
to say temporary, he has
temporary
temporarily
for
retained.
What?
Temporary retaining.
Temporary retaining, he's saying.
Temporary, will that attract the provision?
My lord, these are the observations, my lords. If your lordship may come to the charge part, my lords. Page 40 is the charge. In charge, it is very clear, my lords. Lordship, what is my lords? Page 40. Charge part, my lordship. Page 40, my lords.
Page
40, my lords. 40.
But what, how will you justify that 13.2 and 13.1C and all?
Does misconduct, my lords?
To PCA?
Yes.
And 409.
Being a public servant has misconduct himself. And 409 is for criminal breach of trust.
This judgment is not very happily worded anyway. Yes. Charge, what is, where
Page 40, my lords.
40, 40.
40, my lords. They have categorically stated about section 409, the second para.
40, okay.
May I place it, my lords?
Second
para.
Range officer during the period of yes.
So there is no defect in charge, my lords. That apart, my lord, section 464 is also stating at the accused of CRPC. Defect and omission of charge. Lordship knows, my lords.
Then how
They
do
have to
they
substantiate how there was a failure of justice.
The trial court has also held in paragraph 12, my lord. How do they overcome, my lord, the deposit of 73,000, my lord? That he has to give explanation, my lord.
Okay.
Judgment reserve, judgment reserve.
So much I have heard without.
I am obliged, my lord.
I think you should you improve your this thing, written submission. In the written submission, you have
I've
given
cited
fact
that
sheet.
judgment also. Yes. I've cited that judgment and quoted, my lord. In the written note of submission. I
No,
quoted all this.
by now the deliberations which you had in between, you might have been wiser now, little bit. You improvise your written submission, and Mr. Rijvi also will give a
Yes,
note
ma'am.
supporting judgment.
Yes, ma'am.
And what is the real troubling is that part, the preponderance of probability part, because onus was on him. He could try to dent the prosecution to some extent. You have to come over that. And you have sufficiently shown from the definition part.
Yes.
That even if the procedure, because you are government service.
Yes.
If the procedure established,
then he has to follow it.
Under the regulation,
That is sacrosanct,
whatever, that has to be followed. Otherwise, the intention
Yes,
flows.
intention follows.
Intention
flows. Yes.
So therefore, the liability is
Yes,
still
ma'am.
there.
I am
So
obliged.
to that extent, you have to answer. And the other part he will answer.
Failing to
Heard Mr.
follow the
K.K.
procedure amount.
Counsel for the appellant and Mr. Rijvi, counsel for the argument heard, judgment reserved. In the meantime, both Mr. Mishra and Mr. Rijvi have filed the written submission along with the relied upon judgment. Within a week.
Okay. Within a week, no?
Note for the judgment, written submission.
Within a week.
Great.
Still you have to prepare little bit more and
even if the entire allegation taken into consideration, well, hardly this is a case of bona fide mistake, my lord. It is a case of bona fide mistake, as held by the Honorable Apex Court.
You are a government employee.
Yes, my lord. For that reason, my lord, there is a separate procedure to initiate departmental proceeding. But that departmental proceeding has not been.
The department has given you sanction.
Yes.
For not following
Otherwise, department
Would not have given, would not have given.
for not not following the procedure, not amounts to any criminal liability.
But
Intent, my
department
lord.
is
What my lord trend is says, my lord.
why sanction provisions? Because unnecessary, the officers will not be put
into trouble.
trouble. That is the idea.
Yes.
The department has taken a view that no, there is some criminality, so go and face it.
Yes.
That if there would not have been sanction, there is something different. And you are lucky that no departmental proceeding was initiated.
Non following the procedure is not amounts to be a departmental proceeding case, not the criminal liability.
But he has shown from the provision
My lord.
that the provision itself says that if the procedure is established under the law, that you have to deal with a property entrusted to you in accordance with
In
the
a
law
particular
as
way.
established.
I don't dispute
You have
that,
to
my
do
lord. I don't dispute, my lord, there was an entrustment, but the reasonable
No,
excellence.
entrustment and dealing with that.
No, no,
property.
no reasonable
Entrustment is no doubt. You are saying, he is saying. You can't deny that. After entrustment, how you deal with the property?
Grateful.
That can say, my lord.
That's very important.
No, my
That's
lord,
very-
that can say, that he can say, my lord, after the end of session, my lord. In the midst of session, he can say.
No. What he says that you try to
Yes,
find
my lord,
out
I
the distinction.
my lord,
Your argument is the end of the session, it could have been done.
my lord.
But the evidence has come on record to show that from the beginning when you joined, you have not
Not
maintained
maintained.
anything.
Yes.
And evidence has also come that you have given the advance, no
Yes, my lord.
voucherage of taking.
For that reason, my lord, no penal provision is there, my lord.
The
No
section says that
No
you-
penal provision is there. my
No,
lord, for that.
section itself, 405 says that if its procedure is established
You have to
deal with
follow.
a particular
Charge has to be
interested
framed,
property.
charge has to be framed on the section
Especially, my lord,
405,
public
my lord.
servant.
No, no.
Charge has to be
Especially
framed.
public servant.
Yes, my lord, I will cite that judgment also, my lord.
409
Yes, my
suffice
lord.
for that.
Yes, my lord.
Yes.
I will cite
That is the danger you have.
Yes.
Yes, my lord.
And
That's
your
the
lordship,
keen danger you have.
and lordship, your laws, my lord, 1960 Supreme Court, Ramchandra, when a thing has to be done in a particular way, statute
That has
provides,
to be done.
it has to be done in that.
But the provision itself mandate you because you are a government employee.
Right.
It is entrusted to you. Procedure is, see, to check and balance, regulation is there, procedure is there, how to deal with it. You don't deal with it. If had it been an isolated case, one day or one dealing, this thing, I can understand.
Or even if
right
only-
through you are not
Yes.
doing it.
Or even if during that only joint verification period.
Right through you are
Yes.
not doing it. Therefore, under the provision of 405, you are supposed to do it, you are not doing it. Even if preponderance of probability, you can be held liable. That is his argument.
Yes.
You have to deal with that and give it.
Great.
Okay.
Yes.
Any, sir is sitting, just ask. Yes, sir.
I have two matters, 59 and 60.
59.
My lord, item 57.
1 minute.
My lord, I
1 minute, sir, 1 minute. It's going on. Yes. 59. 60.
May I submit, my lord?
Are you ready?
My learned senior is there. Item 59, my lord, I will conduct the cases. My lord, I will not allow my learned senior to argue. This is a matter, my lords. The accused in this case was a peon in the government department, my lords. In a bid to help his mother, who had breast cancer, my lords. And he had gone with his mother to the cancer hospital, Cuttack, my lords. And the doctor PW10 advised them to go for a medicine. And thereafter the process started. He has submitted cash memos that was viewed adversely, and case started, my lords. And in the meantime, the important aspect in favor of my learned friend is that sanction was short for. It was not given. That's why, my lords, all the provisions under the Preci Act was were dropped, and they were prosecuted under the IPC provisions, my lords.
What are the IPC?
The IPC provisions, my lords.
16%.
Yes, my lords. And my lord, the entire thing, my lords, started when I was going through this judgments, my lords.
Yes, sir.
468 and 471. In fact, that was the learning trial courts. And they have taken the grounds that why the vigilance courts dealt with these matters pertaining to IPC laws. But that is not feasible because of the ground that no power was given to that particular court when the case was initiated in that court. Thereafter, they preferred an appeal. But the fact remains that everything, the all controversy revolves around the cash memos. And admittedly, the peon, the accused before the petitioner before Lordship Lords, had gone to Acharya Harihar Cancer Institute, Lords, in the year 2003, Lords, which is
manipulated the prescriptions.
Then the cash memos, 2 cash memos, Lords.
Cash memos of the medicine shop.
So thereafter, Lords, that for
When
the
you was
development
getting reimbursement of that money.
reimbursement, and it was and they got that advance of 60,000 rupees for treatments, and thereafter that was processed, Lords, and ultimately I come back to the main point in their favor is that sanction are short words.
That part is gone.
He being a public servant, Lord, they wanted to use patient to service the section 13 of the IPC Act, Lord. That was dropped, right? And IPC provisions 468, 470 was patient to service. And Lords, the grounds they have taken many other grounds, Lords, but here the ground for the prosecution, Lords, primarily hinges on exhibit 5/4 and 5/7 minutes. These are the PW4 and 6, the medicine storekeepers, and the 4 cash memos. It had overwritings on the cash memos.
It is true.
These are the foundation of the prosecution case. The exhibit 5/4 and 5/7, the 4 cash memos, and 5/4 to 5/7.
Medical store.
That medical storekeepers.
They've said that it's manipulated.
And the PW4 and 6 are the witnesses on which the prosecution stands.
They supported prosecution.
And
that 460,
now
how will you get out of 468 and 471?
468, 471.
No, 71. The 2 vouchers.
No, not the 2, not the 2, 4.
Huh?
4 cash memos.
4 cash memo, which you had manipulated, that is exhibited and proved by PW4 and 5.
1, 4, 6.
1, 4 and 6. PW1, 4 and 6. How will you get over it?
Most of your statements, most of your submissions, I'm grateful that it goes in my
No, I put both the cards.
That's the fair enough for a prosecutor to say whatever is correct.
Yes.
Yes. Who wins, who loses is not more important. You have to assist the court. And how will you get over this, the exhibit which has been proved on record?
Because I have come to my 60.
Yes. She is very competent.
No, in fact, she is very supportive.
I'll give you opportunity.
Lords, I can give one hint to her, Lords. PW10, the doctors, Lords, in that cancer hospitals, he has recommended to the petitioners who was a peon with that his mother had breast cancer, Lords.
That's right, but these are morality issues.
No, not morality, Lords. On the basis of that, Lord, he purchased that medicine.
And so cash memo, you can't
in a bit to fulfill his greedy.
To help. But he is a peon, obviously.
But my Lord, I am hopeful that she will overcome that PW146 with regard to exhibit 5/4 to 5/7.
Tomorrow I will give you 2 o'clock. You prepare it, get over it. See, otherwise, the sentence, I can extend the benefit of provision of offender tax, that is easy thing. But it will not help you in the sense he was working as a peon and he'll get the departmental benefit, whatever he is supposed to get.
From the statements of PW4 and 6 and present before your lordship, there are certain statements.
Try to find out some kind of doubt so that we will record an acquittal so that poor guy will get departmental benefit, whatever, retirement benefit. Okay. Otherwise, leaving him in probation will lead nowhere. Because see, the problem is he was, his mother was suffering from cancer. Doctor has prescribed. And he must be having financial problem, obviously.
In a bit,
So out of desperation to save
maybe
the
he
mother.
cannot resist the temptations to get something more and
No, out
got
of
the money of
desperation
60
to
for
save
this.
for the mother. Because working as a peon, he might have done it.
She was suffering from cancer, is not disputed. She was undergoing treatment in that hospital, Acharya Harihar Institute of Cancer, is not disputed. She has spent some amount and purchased medicines, not disputed. The two memos, my lord, who said that it was some overeating, suspecting that must have been
That is
tampered. That must have
468.
been tampered. That must have been
That is
tampered.
468.
And there is also
What to do?
concrete evidence to show that has been tampered.
Create some doubt in the
Create some
prosecution.
doubt, yes.
So
Your
that
lordship-
under the
your
benefit
lordship-
of doubt, we
Yes, your lordship used the right word. Create some doubt.
some doubt.
This again, yes.
Clever. Whole day, whole night you prepare and come tomorrow. Sir will not argue, you will argue. Okay.
Your lordship virtual has completed create some doubt. That means, my lord, any doubt, always the benefit of the doubt goes in favor of the accused. That is the basic principle.
Little doubt also you
That
create.
Any doubt, my lord,
That doubt, on the basis of that doubt, in the benefit of doubt.
always given to the
you will
accused,
be
my lord.
able
That is the basic principles of criminal law. Any doubt creates, my lord, that
I come with judgment.
the accused gets the benefit.
He is tilted towards the accused, then. Okay. Tomorrow, huh? 2 o'clock we'll have.
60.
60 is I think my learned senior will not get adequate time to praise his king, but if he
Today
stands.
60.
In fact, this is a third time, my lords. I've been crushing short with my learned senior on this particular case in 3 courts, my lord. Unfortunately, he has the the fag of every day. Last court also, if I end board,
This is a big matter. Or
get time like you.
time like
This is small matter.
No, for my senior is
No, so for my client is concerned, against him only 177. No conviction under the PC Act.
170.
177 only. 1416.
Oh, there
Hemanta Kumar
are
Saurabhi.
3 matters, huh?
Hemanta Kumar Saurabhi.
There is one appeal also, my lords, attached to it. It is
That
at
is not.
597.
I am not appearing in that case.
The other counsel is
2010.
Commissioner Sobri Mahapatra, no. Let it be there in the list only. See tomorrow, day after, any time.
tomorrow.
Not tomorrow, day after.
Are 2 big matters.
No, 2,
Let it
he is
hide.
going to argue.
No, my senior is talking about item 60.
Yes.
Tomorrow.
Not tomorrow.
No, not
Not tomorrow. I'm
Tomorrow.
not-
Yes.
Let it be there. Let it be there.
Yes.
We'll see when.
I
we can
assured
accommodate.
my learned senior that this will be taken up in preparation.
Okay.
Thank you.
I assist all the.
This week?
Next week.
Next week, but bereft of 15 and 16, that too, Mr. Kanun, Milan Kanun was big matters are coming. Take some time.
Give, just see when we can.
19 for you. 19 for you. 19.
Let's just report.
Yes.
18th man, 18th.
18th, no, 18th, lot of matters.
A lot of matters are on the, will be coming on the board.
Especially we kept lot of matters.
The next week I will be at Delhi, my lord.
Then, my lords, in the week commencing 22nd, my lords.
22nd.
Yes.
22nd at 2,
My lord.
2 p.m.
22nd.
At 2 p.m.
Yes, ma'am.
Yes.
No problem.
My lords.
2 p.m. So that time is fixed, you need not waste time.
Yes, my lords.
I'm okay.
Yes. Any mentioning? Or all the matters will remain in the board?
Yes.
We'll see.
I got one permission below. Item number 84, my lords,
Let it be.
can be disposed of. Let it come tomorrow. my lords.
It's there on the board.
Mention it tomorrow.
Grateful, my lords.